236, so I am mentioning now. One hearing matter serial 19. I was just saying that earlier according to Prince directed that you apply for the certified copy and get it. In spite of that, I applied only judgment copy.
Which is that case? Serial number?
90. It's money appeal. Only I was praying. It's my request that if a copy by mail or whatever, day after tomorrow, any day may be fixed and if given, I am ready to have it. I have a copy of judgment also. Serial 90, second case of hearing. Entire documents I applied, but I was not required.
'When did you?
50 days back. Only judgment copy they gave.
2005 का matter है. This you are the appellant. You have drafted the appeal without the records.
I have not drafted it.
Whosoever has drafted it.
It came to me, file misplaced. The other side was also not having. They also not having the copy. So only.
या तो अभी टेक अप ही नहीं होगा. इसमें कोई ऑर्डर पास करने की कोई जरूरत नहीं.
इसका अगर कॉपी मिल जाता.
किसका क्या कॉपी दे रहे? रिकॉर्ड इनको यू डू नॉट नो. इनको स्लिप दीजिए, सारा रिकॉर्ड इनको पढ़ने के लिए दे दीजिए. You will get entire records to read. Read all the records.
हम मेल आईडी से मिल जाता.
नहीं है ना, स्कैन नहीं है. 2005 का स्कैन नहीं होगा क्योंकि वो बहुत पेपर बहुत खराब है. उतना पुराना रिकॉर्ड स्कैन.
हुआ था देने के लिए, उसके बावजूद हमको नहीं मिला. हम अप्लाई किए.
कंटेम्प्ट फाइल कर दीजिए. ठीक है. You file a contempt. We'll settle the matter in contempt. I'm telling you that the records will be available to you. आप सुबह से शाम तक पढ़िए. कौन मना किया आपको? स्लिप दीजिए, रिकॉर्ड देख के पढ़िए. आराम से एक कोना में बैठ जाइए और पढ़ते रहिए रिकॉर्ड.
Serial number 59. I only may continue to take.
Who is there for the? You are for the petitioner. क्या हुआ उसमें? Why was it adjourned on the last date?
Lordship, LPA was pending.
LPA has been dismissed. Who is there for the other side?
I will inform.
Sawad inform him.
Serial 59.
This case from Readiness, Item 4, second to 78 of 1999.
Just one more thing. We have not factually, I want to just inform your Lordship, not so far as that Bonafide, because your Lordship will decide section 19.
आपको सुनने में कोई कमी किए थे? अभी आपका आर्गुमेंट खत्म नहीं हुआ.
हम खाली एक चीज नोट 2 मिनट के लिए बता रहे हैं. खाली नोट your Lordship is seeing not so far as payment in Bonafide. So note the sale deed is dated 25/1/1980. On that date, note the sale deed only there is a recital that 10,000 and 10,000 is being paid, and 15,000 and 10,000 will be paid later on. That is recital in the sale deed on 25/1/80. Therefore, note our only point is that our Bonafide should have to be tested on the date of the sale deed, because it was our obligation to pay the balance amount in terms of the sale deed. And before sale deed, we had no knowledge. This is only a point. Just clarify this point. So, for the Bonafide. Okay. And sale deeds are Exhibit A and A/1.
learned counsel for the defendant number 2 and 3. I submitted that as per the two sale deeds executed in their favor, that is Exhibit A and A by 1 respectively, the consideration amount was rupees 20 lakhs and
20,000.
20,000 and 25,000 respectively. Wife ka tha 25.
Wife का 25, husband का 20.
20,000 and 25,000 respectively, and in the deed itself it was mentioned that 10,000 only was paid at the time of registration and the remaining was to be paid later on. We have submitted that under such circumstances the balance amount having been paid later on, the said payment is in good faith and therefore there is no violation of section 19B of the Specific Relief Act. He has also referred to paragraph 17 of the written statement, wherein it has been asserted that the balance amount was payable and at the time of the written statement some amount was still due, which they were ready to pay, but the vendor had not vacated the one room and therefore the remaining was not paid.
And subsequently, the remaining also was paid.
And subsequently, during the pendency of the case, the remaining was also paid. The vendor vacated the premises and handed over the possession to the defendant number 2 and 3.
And the entire possession. Okay.
Lordship, first I'll start directly from the two judgments which have been placed by and relied upon by the respondents themselves. Your Lordship may kindly take up the 2023 volume 11 SCC page 775. This entire judgment is with regard to the capacity of the plaintiff to pay the consideration amount and whether and how the readiness and willingness has to be seen by the court. Now, Your Lordship, the basic difference in our case and the case before the Honorable Supreme Court, why it was there, Your Lordship may kindly take up para 11 itself. From day one, I am arguing that it was essential for the defendant to have taken a plea in the written statement denying the fact of readiness and willingness. In para 11, it has been stated, the original defendant has categorically stated that he did not agree to sell the suit property to the respondent plaintiff as alleged and he did not receive any advance on so and so as alleged or any other date. It is the case of the appellant that there was no concluded contract to sell the suit property. In the written statement, it is also pleaded that in any case, the respondent plaintiff was never ready or willing to perform his part of the part. So very specific plea was taken in this particular case, and then therefore issue number 4 was framed that whether the plaintiff was ready and willing to perform his part of the contract. Issue number 4 specifically was framed.
So in absence of any written statement by defendant number 1,
Yes.
there was nobody to controvert this.
Yes.
Because respondent,
Why this was
defendant
there?
number 1
Yes.
did not participate in
Yes.
the proceedings, did not come forward to depose in spite of their request.
Yes. So defendant number 2 and 3 also
See,
could
their
have taken.
cases, let's take it to a different one. Their cases that the readiness and willingness, the initial onus is on the plaintiff to
Yes, absolutely.
say about the readiness and willingness.
I'll answer all the queries. Your Lordship, I have those judgments also. I'll come to that also. First, I wanted to meet the question which was raised in this by this particular judgment. Therefore,
By referring to the judgment relied upon by the respondents and reported in bracket 2023 bracket close 11 SCC 775, the learned counsel for the appellant has referred to paragraph 11 of the said judgment to submit that in the said case, specific plea was raised in the written statement that the plaintiff was never ready and willing to perform his part of the contract, and therefore a specific issue was framed as to whether the plaintiff was always ready and willing to perform his part of the contract. He submits that the defendant number one in the present case, who is the vendor, never participated in the proceeding, never filed any written statement, nor came forward to the court to depose, in spite of the defendants having asked her to depose before the court. SIN evidence.
वो उसमें आया.
हाँ.
And
Just a moment. To depose before the court, but in such circumstances, the defendant number one, who was the person who could have questioned the readiness and willingness on the part of the plaintiff to perform his part of the contract, could not controvert the statement made by the plaintiff that the plaintiff was ready and willing to perform his part.
And now, because the defendant is taking advantage of being a bona fide purchaser, and therefore he was required to at least take this plea of readiness and willingness. In his written statement, he was required to have pleaded or denied the fact of readiness and willingness. If you wanted to raise it here, he is raising it here for the first time.
The counsel submits that even the defendant number 2 and 3 did not specifically take any plea regarding absence of readiness and willingness of the plaintiff to perform his part of the contract. And accordingly, he submits that the parties did not join issue on the point of readiness and willingness, and for the first time before this court, this plea of readiness and willingness has been raised, and a substantial question of law has been raised.
Only that word may be noted, that controvert. They did not controvert my statement with regard to readiness.
And he submits that the respondents, who were defendant number 2 and 3, did not controvert the statement made by the plaintiff regarding readiness and willingness to perform his part of the contract.
Then para 20. All these things have been answered in the instant judgment itself. Para 20 it says that it is well settled that in a suit for specific performance of an agreement, it is for the plaintiff to prove his readiness and willingness to perform his obligations under the agreement, where a certain amount has been paid in advance and balance is required to be paid within a stipulated time. It is for the plaintiff to show that he was in a position to pay the balance money. The plaintiff has to prove that he has the money or alternatively made necessary arrangement to get the money. In this case, very important, in this case the appellant to original defendant have all along contended that the plaintiff respondent neither offered to pay nor was in position to pay the balance concession amount of Rs 15. Very distinguishing feature here. Very specific plea, and it was contention also.
While further distinguishing the aforesaid judgment, the learned counsel has referred to paragraph 20 of the judgment and has submitted that the Honorable Supreme Court has held that when a certain amount has been paid in advance and the balance is required to be paid within stipulated time, it is for the plaintiff to show that he was in a position to pay the balance money. The plaintiff has to prove that he has the money or has alternatively made necessary arrangement to get the money. And in the said case before the Honorable Supreme Court, the appellant, the original defendant, had all along contended that the plaintiff respondent neither offered to pay nor was in a position to pay the balance consideration amount of Rs 15 lakhs.
Then para 26. In Prem Raj versus so and so, cited by Mr. Venugopal, this court speaking to so and so said that it is well settled that in a suit for specific performance, the plaintiff should allege that he is ready and willing to perform his part of the contract, and if the fact is traversed, he is required to prove a continuous readiness and willingness from the date of contract to the time of hearing to perform the contract on his part. So therefore, there has to be this fact of readiness and willingness has to be traversed by the written.
The learned counsel then referred to paragraph 26 of the aforesaid judgment, which in turn refers to the judgment reported in 1968, AIR 1968 SC 1355 within bracket Premraj versus DLF Housing and Construction within bracket Private Limited, and has submitted that the Honorable Supreme Court has held that it is well settled that in a suit for specific performance, the plaintiff should allege that he is ready and willing to perform his part of the contract, and if the fact is traversed, इसको italics में डालेंगे boldly and underline, he is required to prove a continuous readiness and willingness from the date of the contract to the time of hearing to perform the contract on his part. The learned counsel submits that the question of demonstrating continuous readiness and willingness after having stated in the plaint about the readiness and willingness by the plaintiff is required to be further proved if such statement is traversed in the written statement. In absence of any contrary statement in the written statement, the readiness and willingness having averred and stated by the plaintiff in the evidence was sufficient.
In denial, your lordship may use the word denial. That in absence of any denial with regard to the statement made by me with regard to readiness,
In absence of any denial with regard to statement made by the plaintiff regarding his readiness and willingness to perform his part. आगे बढ़िए.
next, your lordship may kindly, if your lordship will take up 2024 SCC online, P. Ravindranath. There are 10.
With the aforesaid submissions, the learned counsel submits that the judgment relied upon by the respondent reported in bracket 2023, bracket clause 11 SCC 775, when read as a whole, does not help the respondent's opinion.
In
Mr.
para
Para
10
11.
of this judgment. Defendant number 1 to 5 have filed a common written statement which briefly raised the following issues and objections, and C may kindly be seen. C. It was next stated that the plaintiff were never ready and willing to perform their part of the contract at any point of time, which was agreed to be 3 months or even thereafter. The defendant had also repeated notices, but despite the same, the plaintiff never came forward to clear the balance amount. As defendants were in need of money, they were left with no option but to execute. So absolutely specific plea was taken here.
Did you ever give any legal notice? No.
Yes, we are given that also will come. That also.
With respect to the judgment reported in 2024 SCC online SC 1749, the learned counsel has referred to paragraph 10, which deals with the commons written statement of the defendant number 1 to 5 of the same case, and has in particular referred to paragraph C, subparagraph C thereof, to submit that it was a specific plea of the defendants that the plaintiff were never ready and willing to perform their part of the contract at any point of time.
Yes. Then your lordship, another is 1995 volume 5 SCC, page 115. NP Thiru. No. Para 5
Counsel
itself.
submits that. The judge, the aforesaid judgment is clearly distinguished
Yes.
from facts. And this AC से बहुत परेशान है. This is the actual cause of my throat infection. For last 4 days, I am running high fever. बस यही बोला है कि आप AC में बैठना छोड़ो.
All
उपाय
these
लगा रहे.
windows can be opened and up to
तो थोड़ा मौसम ठीक होगा.
हाँ, ये सब cricket
We'll
मिल
try
जाएगा.
and figure out.
Mr. Sinha has been suggesting in all other courts. ये open कर लें.
I have been suggesting many things, you know, that this building is a waste, absolute waste, and it is just not the court closed. You know, to go outside and see what is the condition outside. There is no ventilation. There is no air conditioning. There is no ventilation. Fans were put. Fans are of no use. Air coolers put. I don't know, half the air coolers have disappeared. The kind of difficulty we face outside in the atrium, so-called atrium, is unbelievable. There is lack of oxygen, I believe. Everyone falls sick. This building, I don't know.
And all the doors also are closed.
There's no
So
आप
if-
लोग कोई अच्छा रिप्रेजेंटेशन दीजिए, फिर किसी अच्छे आर्किटेक्ट को बुला के हम लोग किस ऑप्शन we will figure out the option.
Just imagine, your lordships, this is actually your lordship's chambers are, there is no fresh air. I don't see any fresh air coming to the chambers.
Got it.
Everything is closed.
Everything is closed. और बता दिया गया है अगर खोल लीजिएगा तो सांप भी आ सकता
कहाँ से घर से ऊपर से सांप कहाँ से आएगा? ऊपर से पानी आएगा?
है. साइड से
हाँ, सांप
खिड़की
तो
खोल
बाद में
देंगे तो
आएगा।
सांप भी आ सकता है.
I also agree with my learned friends. I never wanted to say because this is almost
लोग
over.
बोलेंगे एज हो गया तो इसलिए बोलते हैं. इसलिए
नहीं
आप
एज
बोलते हैं.
नहीं. अब बोल के क्या हो गया? तो वेस्टेज ऑफ मनी. इतना कॉरिडोर में पैसा लग गया सीमेंट का, कोई फायदा नहीं.
It's all
फिर
falling
आप लोग
apart.
कुछ एक रिप्रेजेंटेशन बना के दीजिए.
हम लोग दे सकते हैं.
सब
I
दिया
am a
है।
part of the building committee. We will
Very
take care of it.
Very good.
एक बार देखे तो देखिए, कुछ तो हम लोग
ठीक है,
पता
ठीक है,
करेंगे ना,
ठीक है.
कुछ फाइल लगाएंगे हम.
दरवाजा सब खुला रहे तो पूरा वेंटिलेशन होगा.
ऐसा
सारा
है,
दरवाजा बंद.
अगर
खोल
अभी
लीजिए. सब विंडो खोल दीजिए.
अगर अभी फायर हो जाए, there is only one exit in block 1 and one in block 2. कहीं नहीं.
खोल दीजिए ना, इसको पर्दा हटाइए, खिड़की खोलिए.
कोर्ट नंबर 24 में खोला रहता है.
वहाँ तो अच्छी एडवांटेज है कि इट्स ओपन टू दी।
हाँ, यहाँ पे खोल दीजिए. If permitted, we will definitely.
एक रिप्रेजेंटेशन दीजिए, देखते हैं कुछ तो होगा.
I will not personally write because I don't have. I will have
किसी
to
का
write
जरूरत
personally.
नहीं है ना. जेन्युइन कॉज के लिए किसका सपोर्ट
नहीं
चाहिए?
नहीं चाहिए. I have few suggestions.
You write it yourself.
Your Lordship, this judgment
95.
1995, para 5, Your Lordship, my learned friend has already referred. I'll only place the last page of the same judgment, page 118, after 5-6 lines, because all other portions are already will be repeating. To adjudge from the middle portion, Your Lordship. This after 5-6 lines from the top,
Last page.
page 118.
After 5-6 lines from bottom.
Para 5, approximately 12 lines
Okay, I
of para 12.
Yes,
To adjudge,
That's right.
to adjudge whether the plaintiff is ready and willing to perform his part of the contract, the court must take into consideration the conduct of the plaintiff prior and subsequent to the filing of the suit, along with other attending circumstances. The amount of consideration which he has to pay to the defendant must be necessity be proved to be available right from the date of execution till the decree must prove that he is ready and willing and has been ready and willing to perform his part of the
This
contract.
is what he is harping on. He
Yes,
says
yes,
that
I'll show. Therefore, I'll show from my own evidences. I'll show what is required to be shown. Then last 2 lines, the court may infer. This word is important. May infer from the facts and circumstances whether the plaintiff was ready and willing and was always ready and willing to perform his part of the contract. Now, how this has to be done? There are other judgments also. So I'll place those judgments subsequently. Now, Your Lordship may.
the learned counsel has referred to the judgment reported in bracket 1995 bracket rules 5 SCC 115, which has been relied upon by the respondents, and has referred to the last portion of paragraph 5 thereof. To submit that the readiness and willingness to perform the part of the contract has to be necessarily decided on the basis of conduct of the plaintiff seeking, conduct of the parties,
Yes.
conduct of the parties.
And let us assume more so of the plaintiff also. Let us also say that I have to show that whether I was ready and willing, I'll show. Now, Your Lordship may kindly
Is there
see.
any judgment which deals with what is the foundational pleading for readiness and willingness?
No, it says that basically that same language is not required to be exactly stated in it. There are several judgments. I'll show those also. But Your Lordship, here is a fact where the honorable courts have held that the court have to see in substance whether the plaintiff has made this statement or not. He is not required to make us exact words used in the specific relief. But the court has to see whether he was
Can he
ready.
mechanically use the term readiness and willingness in his plaint? Or he has to do something more?
That is only thing that the
Because
specific relief act.
technically, plaintiff picks up the word from the statute and pastes it in the plaint. Is that sufficient?
Then he has to prove both readiness and willingness.
So it is
other
the onus is certainly upon the plaintiff to prove
yes,
readiness
yes,
and
yes,
willingness.
yes, I'll come to that
Right?
also.
And if there is an onus on the plaintiff, and unless that is actually discharged, where does the onus shift upon the defendants, irrespective of the fact that the defendant number one has not filed the written?
Yes, I'll answer that also. I'll answer.
Just to answer your Lordship's question.
अभी
I
बेटा,
did not
No, no,
disturb
आपको
you.
दूसरा कोर्ट में जाना है?
When
आप
was-
जाओ।
No, no, it's not a
on the
question.
last hearing, I did not
Please
disturb
don't,
you.
please.
I did
It's
not
not a
come
question
from
of
outside
disturbing.
to-
Your Lordship asked a question statutory. There is a statutory pleading of specific performance which they meet. I'm helping him. Why do you always think I'm not helping you? I think your pleading is sufficient as per Form 47 of CPC, which is a statutory form. Please, why do you jump to conclusions?
Form
Because
47.
Form
Because I-
47, CPC, my lord, there are pleadings, forms, and that the Supreme Court says they are statutory form. I think there's sufficient pleading in paragraph 7. Please understand. That's something you have to against you. Let us not argue on law, not.
It is in appendix.
Yes, it is appendix, not appendix A.
Appendix.
Appendix A forms are given.
Form 47.
Form 47. So their paragraph 7 is in conformity with Form 47.
The learned counsel for the appellant has referred to Form 47 prescribed under CPC under Appendix A and has submitted that the requirement of a pleading in connection with specific performance of contract has been prescribed therein, and the pleading of the plaintiff is in conformity with Form 47. And therefore, nothing else was required to be pleaded so far as the plaintiff is concerned.
I don't have that judgment right now, Your Lordship, but it is referred to in this book itself that if Your Lordship takes up the specific relief act where this judgment has been quoted up to the year 2000, where it says that an averment of readiness and willingness in the plaint is not a mathematical formula which should be only in a specific words. If the averment made in the plaint as a whole to clearly indicate the readiness and willingness of the plaintiff to fulfill his part of the obligation.
On the face of this form, do you need that?
No,
Not required.
because Your Lordship put a query whether
Because I had no
Yes.
idea about this form. Thanks to Mr. Singh.
yes. Thanks.
You better thank him.
Yes. So, Your Lordship, in view of this particular pleading, I had made a statement in para 7 which was not denied by them in para 7 of their written statement. Then, Your Lordship, my second ground would be that we had sent a notice prior to filing of the suit. That was dated 27th of June 1980 and it was marked as Exhibit 1.
So,
Yes. Your
So-
Lordship, may kindly. Yes, yes. All three are there. Notice, acknowledgement
and
and
receipt, postal
receipt.
receipt. Like exhibit.
1, 2, 3 they have been marked as.
The learned counsel has referred to the notice, legal notice sent by the plaintiff, which is dated 27/6/1980, marked as Exhibit 1, the postal receipt, Exhibit 2, and the acknowledgement, Exhibit 3, and has submitted that readiness and willingness is demonstrated through the said notice also, to which the defendant number 1 did not respond.
Yes. If your lordship would see the notice.
हम तो एज्यूम करिए कि आप यही बहस करेंगे। ये कागज देख देख के आपको समझ में नहीं आ रहा। You can't even ask them to.
1 page notice. It is by Shiv Sevak Singh, advocate.
Exhibit 1. This is defendant's exhibit. Exhibit 13. Exhibit 1. Exhibit 1 is
Mr.
Exhibit
Sinha may
5
be
by A
allowed to
session.
leave here.
Sure. आपके पास है कॉपी?
हाँ.
इसको एक फोटोकॉपी।
I'll just pass it on. Your lordship, I'm just reading 1 page. Second paragraph is that it was agreed by you that the sale would be effected within 2 years from the date of agreement, and my client shall pay you the remaining balance of the concession amount of rupees 39,000. My client has always been ready and still ready and willing specifically to perform the agreement on his part, and how.
एग्रीमेंट का डेट क्या है?
5/8/1970.
I may be allowed to read this, very important, because I'll be relying on few judgment also.
The legal
Because-
notice is quoted as under.
Yes.
Quote कर देते हैं हम लोग.
And my client shall pay you the remaining balance of the concession amount of rupees 39,000. My client has always been and still ready and willing specifically to perform the agreement on his part, and now he applies to you to specifically perform the agreement on your part within a month from today, failing which my client will approach the court and do for the deed. So he.
The learned counsel has submitted that the perusal of Exhibit 1 reveals that it was specifically stated therein that after that the agreement was executed on 5/8/1979 for consideration amount of rupees 40,000. Rupees 1,000 was already paid, and the sale deed was to be executed within 2 years from the date of the agreement. However, much prior to expiry of 2 years,
Yes.
the legal notice was sent stating that the plaintiff was still ready and willing to perform the agreement on his part, and he applied before the defendant number 1 to specifically perform the agreement on her part within a month from the date of the legal notice, failing which the plaintiff would approach the court for needful. The learned counsel has submitted that this legal notice, having not been responded, stood admitted by the defendant.
Yes. Though
Readiness-
received.
Though received.
Yes.
though received. He also submits that the conduct of defendant number 1 also becomes important, as she neither filed a written statement nor appeared before the court to controvert the stand of the plaintiff. He has also submitted that once there is an agreement stating that the balance is to be paid, that the final sale deed is to be executed within 2 years, there was no occasion for the defendant number 1 to part with the property prior to expiry of 2 years. यही बोलना चाह रहे हो?
Exactly.
चलिए, इसको
And-
कॉपी करिए, इसको क्लिक कर लीजिए और इसको आप छाप देंगे उसमें.
And only thing what a purchaser is required to do, only thing he can do is that he is required to pay the concession. That is the only thing. Nothing else, because the property belongs to the vendor. And upon payment, I can only offer the amount which is to be paid by him. So rest is absolutely to be done by the vendor or owner of the property. Here I offered the amount, that is all. Now they do not respond, they do not, and they instead transfer the property to a third.
क्या 2 साल पहले ट्रांसफर कर सकते? Suppose a person is not ready and willing to perform within a period span of 2 years, as per the agreement.
Yes.
Can they still transfer the property?
Then, Your Lordship, then I must concede to this effect. Mr. Sinha was right on that. That if even then I am required to establish my readiness and
From
They-
when? After the expiry of 2 years, or right from the date of the agreement?
according to me, I have to prove my readiness and willingness during the subsistence of the contract. If I do,
No. The contract is that you will pay within 2 years.
yes,
Right?
Yes.
A party who is contracting, he is
I
he is
get you.
anticipating
Absolutely.
that I will sell this property
Yes, yes.
and get this
yes,
this money.
Yes, yes,
And before the person takes steps for that,
yes.
the property is sold.
I do get Your Lordship's point. Yes, then prior to 2 years, my willingness cannot be seen, because if I do not pay within 2 years and 2 years lapses, then it can be said that I was not ready and willing to perform.
You need to respond to this. Yes.
Yes, I stand corrected. So
The learned
here,
counsel has submitted that there was a time frame of 2 years from the date of the agreement for agreement में check कर लीजिए.
हाँ देख लो,
For-
because notice
for-
में लिखा है.
Getting the sale deed executed and making payment. Agreement में check करिए, agreement में. आपने notice में लिखने से नहीं होगा. Fact में error नहीं होना चाहिए.
नहीं एकदम नहीं.
Agreement में 2 साल लिखा है क्या?
अभी करीब 2 साल केवाना वसूली के तामील होना संभव नहीं है, इसलिए लेखियाधारी से 2 साल का मोहलत केवाला कलामी करने के लिए वक्त मांगे व 1000 रुपए बजरिया
Now
एग्रीमेंट हाजा
He
बतौर
submits that the time frame for making the balance payment was of 2 years, but the property was sold much prior to 2 years.
and this time frame was at the insistence of the vendor itself. It is very
किसी
clear.
के भी insistence
हाँ,
पर there is an agreement बात
because
करता है.
she would have vacated, she would have taken that time. Therefore, she had said that particular period of time, and prior to that itself, she transferred it.
The learned counsel has submitted that the cause of action to file the suit normally might not have accrued prior to expiry of 2 years from the date of the agreement. In case of refusal by the defendant number 1 to execute the sale deed, but in the instance case, since the property was transferred much prior to that,
Yes.
the legal notice was given and the suit was
Yes, exactly. Missing. Now, Your Lordship, my conduct prior to filing of this suit I have shown. My conduct during suit I will show. That can only be shown by way of my evidence, which is there in PW 19. He is the plaintiff himself, and I will only read one paragraph. The parrot. अगस्त 1979 में जो एग्रीमेंट हमने लिया उसका रुपया देने के वास्ते हम बराबर तैयार रहे, वो अभी भी तैयार हैं, वो अभी भी हम तैयार हैं। तगादा भी बार बार हमने केवाला करने के लिए किया, उसमें उसके लिए हमने बीबी सफीरन को बकायदा वकालतन नोटिस भी दिया, इस नोटिस का जवाब नहीं दिया।
The learned counsel has referred to paragraph 10 of the evidence of the plaintiff PW19 and has submitted that pursuant to the agreement, he has stated that pursuant to the agreement, he was throughout ready to pay the balance consideration amount as per the agreement, and still he was ready to pay. He has repeatedly asked the defendant number 1 to do the needful by executing the settlement. For this, they had also given a legal notice, but no response was received. And he has supported his statement by filing documents before the court. This statement has been made in paragraph number 11 of the PW19.
It is 10.
11 में भी है। हमने बयान में जो कहे हैं उसी के संबंधित कागज हमने न्यायालय में दाखिल कर दिया। ये टाइप कॉपी आपको नहीं मिली क्या?
नहीं, ठीक है।
That's right.
Then no cross examination.
हाँ सर, एंट्री बंद करिए। कोर्ट प्रोसीडिंग में यहाँ से एंट्री नहीं होनी चाहिए किसी को।
No cross examination whatsoever on this
He
statement.
submits that there is no cross examination with respect to specific statement made in paragraph 10 and 11 of the evidence of PW19.
Then just another. Now this was during subsistence of the.
He submits that this much is sufficient to show readiness and willingness during the pendency of the suit.
Yes. Now my conduct after the suit. Now the suit was decreed on 11th of March 1988. 11/3/1988. Decree was signed on 23/11. Was signed on 23/11, directing me to deposit rupees 39,000 within a period of 60 days. अच्छा, 11th of March and 23rd of March it was signed. Yes. Then I was directed to deposit the 39,000 in court within 60 days of the order. I deposit on 19/4/1988. That means immediately thereafter, approximately 40 days thereafter.
The learned counsel has also submitted that, as is apparent from the records of this case, the judgment was passed by the learned trial court on 11/3/1988, and the decree was signed on 23/3/1988 with the direction upon the plaintiff to deposit balance amount of rupees 39,000 within 60 days, and he deposited the said amount on 19/4/1988, and it is still lying there.
Yes.
And this amount is still lying with the court.
This
As
is
the judgment of the trial court was reversed by the learned first time.
And this is the note by the trial court with regard to deposit of money and the treasury.
The learned counsel has referred to order sheet dated
21/4/1988.
21/4/1988 with regard to deposit of money by the plaintiff
Yes.
in terms of the judgment and decree by the learned trial court. बताइए 88 से just have
So
nothing to say.
at least the plaintiff cannot be said to be at fault. I prove it prior to filing, I prove it during filing, pendency, I prove it immediately in compliance. So what I comply in toto in terms of section 16, because section 16 what it says, your Lordship may kindly say section 16. Section 16, specific performance cannot be enforced in favor of a person who again C is who fails to aver and prove. Explanation for is for the purpose of clause C, where a contract involves payment of money, it is not essential for the plaintiff to actually tender to the defendant or to deposit in court any money except when so directed by the court. So I was not required to tender unless directed, and as soon as I was directed, I deposited.
The learned counsel has referred to section 16 explanation to clause C thereof. To submit that it has been clearly mentioned therein that where a contract involves the payment of money, it is not essential for the plaintiff to actually tender to the defendant or to deposit the money in the court, except when the court directs. He submits that the moment the court directed by decree dated 23/3/1988, the amount was immediately deposited in terms thereof.
And then,
Deed भी बना था.
वही हम लिखा. I then, after immediately 2 days after 60 days, I filed the execution case. That means I filed execution case on 25/5/1988, which was numbered as execution case number 3 of 1988.
The learned counsel submits that immediately after expiry of 60 days, the plaintiff filed execution case on 25/5/1988, which was numbered as execution case number 3 of 1988. उसमें क्या हुआ?
हाँ बता रहे हैं, मतलब just to show my eagerness to
That's right.
and readiness to get what more I was required to. Then the further thing, as your Lordship put up a query, that what happened to the draft, it was approved by the court on 27/5/1988.
The draft sale deed was also approved by the court
Executing.
by the executing court on 27/5/1988.
Yes.
भाई ये सब चेक करके बताएंगे, हम नहीं चेक कर रहे हैं इसे. इनको दिखाइए भाई, आप सर्टिफाइड कॉपी से इनको दिखाइए.
It is recorded in the order sheet of the
He submits that this fact is recorded in the order sheet of the trial court or the executing court.
executing court dated 20th of August 1990.
Executing court dated 28/20/08
20th of 20 August
of 1988,
1990.
and a certified copy of the order sheet of the executing court has been produced before this court. क्योंकि ये तो executing court का तो record हमारे पास नहीं होगा.
नहीं होगा.
ये certified copy है आपका?
पहले जो हम प्लेस किए.
ये certified copy है.
हाँ, certified copy.
Executing court का certified copy है.
अच्छा हम देख. This fact they may controvert.
I don't know. Anyways, आपने पैसा जमा कर दिया, काफी है ना. बाकी आपका कहानी खत्म.
ठीक है.
However, the records of the executing court is not available before this court, as no such record has been called for.
Last submission, my capacity to pay. It has been, I have shown that my capacity was proved, that I send a legal notice, I say that please come and register the deed, I'm ready to pay, comply with my part. My part meant that I was ready to pay 39,000. Then during pendency, I deposed also. I said that time and again I said, and immediately upon direction I deposit 39,000. Then also, let us assume everything. Then also my capacity to pay was there. Then 2 sale deeds of the year 1973 and 76. I and that means the plaintiff and his wife, they were the purchasers. They had already purchased. And what was the consideration amount? Both the sale deeds are there in record. And the consideration amount was 51,000 in the first deed and 29,000 in the second deed. 5,100. I do stand. 5,100 and then 29,000. So in the second deed it was 29,000. So I had already purchased. It was not a case that I was not purchasing. And all the other cases which have been cited, those were by the middlemen and the persons who were dealing with estate. Such circumstance was not there.
The learned counsel for the appellant has also submitted that the capacity to pay otherwise also cannot be disputed in view of the fact that the adjoining property to the property involved in the present case, adjoining 2 properties, were purchased by the plaintiff / his wife
His wife and brother.
His wife and brother, by paying a consideration amount of rupees 5,100 and 2,900.
29,000. Second one is 29,000.
One is 5,100
5,100 and another is
29,000.
29,000.
which was executed way back in the year 1974,
3 and 6.
1973 and 1976.
6. Those have been marked as Exhibit 6 and 6/8.
Those have been marked as Exhibit 6 and 6/8. Okay?
Last, just conclude kar rahe hain. Now, they have relied on my statement with regard to earlier agreement entered into by me, where I have said that because I could not perform my earlier agreement and therefore I did not have the capacity to pay. This is what they have relied on. Now, that statement I have made in my claim, and that is in 2 portions. I have, in that paragraph itself of my claim, I have said that I had entered into an agreement for sale of the balance property, and the total consideration amount was 36,000. And because I was unable to pay that 36,000, I was getting a smaller portion of the property executed and then this statement, they have denied in toto that there was no agreement, nothing, it is absolutely sham and it has been prepared thereafter. So they cannot do 2 things. They cannot rely on a portion and skip the other portion. If they accept, they have to accept the entire statement in the entirety.
This is paragraph number.
Yes, paragraph is para 5.
The learned counsel for the paragraph 5 of the plaint and has submitted that the plaintiff had disclosed himself about the earlier agreement, which was for a consideration amount of rupees 36,000, and that he was unable to pay. Were you unable to pay?
Yes.
Where in
This,
paragraph 5 have you stated that you were unable to pay?
no, I just, because they were relying on this paragraph 5, I had placed this.
Did you
Otherwise, they
say
have
that-
denied. They have denied this paragraph in toto.
But this paragraph was completely denied by the defendant number 2 and 3 in their written statement.
Yes. Therefore, they cannot rely on this paragraph.
therefore they cannot rely on this paragraph. इसका कोई एग्रीमेंट का कॉपी एग्जिबिट हुआ है?
Then your lordship, other judgments, few judgments, and directly or not based your lordship's time. And I'll try to be specific as possible. ये वाला वीडियो 1997 नोट कर दे देना, इसी को ऊपर दे 1997 volume 2 SCC page 200.
The learned counsel has relied upon the judgment reported in bracket 1997 bracket close to SCC 200
Para 5.
para 5.
Law is not in doubt, and it is not a condition that the respondent should have ready cash with them. The fact that they attended the sub-registrar's office to have the sale deed executed and waited for the petitioners to attend the office of the sub-registrar is a positive fact to prove that they had necessary funds to pass on the concession and had with them.
ये तो वो है ना, prior to filing of the suit. This is the situation prior to filing of the suit.
हाँ ठीक है, तो मैं similarly when I issue a notice that you please execute and accept the concession amount, that is a fact that I had the capacity to do. Therefore I have called
The
upon them
learned
to.
counsel has submitted and referred to paragraph 5 thereof and has submitted that even in a case where the plaintiff had attended the sub-registrar office for execution of sale deed and waited for the same, the circumstance was considered to be sufficient to show his readiness and willingness to pay the balance consideration
Yes.
amount.
And
Just a minute. And even at that stage, it was not necessary for him to actually show the availability of cash. He submits that in the present case, a legal notice was furnished stating that he was ready and willing to perform his part of the contract. And the deed be executed within a period of 1 month. Although as per the agreement, there was still some time left, itself indicates readiness, is sufficient to indicate readiness and willingness on the part of the plaintiff. That's all.
दो जजमेंट, दो तीन जजमेंट है, हम कुछ because your lordship, it is absolutely repeatedly the honorable courts have said that it cannot be in any a particular state jacket formula. It cannot be. Each and every circumstance would be different. So only thing that the court would be concerned is as to whether in totality of the circumstances whether the plaintiff was actually ready and willing
The
to
learned
perform his
counsel has
part.
submitted that the totality of the circumstances and conduct of the respective parties are to be taken together to see the readiness and willingness on the part of the plaintiff to perform his part of the contract. For this, he has relied upon the judgment
Yes,
reported in that.
we put it in 1996 volume 10 SCC
1996 volume 10 SCC
page 51.
page 51 para number
Para number, your lordship, 5 to 8.
para
5, after 5 lines, your lordship may kindly see of para 5. This shows in para 6 of the plaint that the appellant had averred that after the execution of the agreement for sale, he sent registered notice dated so and so to Jana Bhai to execute the sale deed and again sent a notice to the respondent asking them to execute the sale deed, meaning thereby the appellant had been making effort to have the sale deed executed by issuing notices dated so and so, so and so. Then your lordship, para 6.
yes.
Again, apart from the said averment, in the plaint we find that the appellant in his deposition before the court has stated, I issued notices to the heirs of Jana Bhai to execute the sale deed. I was ready to pay the remaining amount and as per the agreement, the defendant did not execute the sale deed as per notice. They replied to my notice so and so, as defendants are not willing to execute the sale deed, I have filed this suit. I am ready to pay the remaining amount immediately. I am ready to pay cost as per agreement. Respondent number 1 has also in his deposition before the court stated it is not true that the plaintiff was ready for sending, but I was not ready. In view of the aforesaid statement of the appellant and respondent number 1 as well as averment contained in para 6 and 10 of the claim, it must be held that the appellant has not only averred but has also proved that he was ready and willing to perform his part of the contract under the agreement for sale. The appellant court and the High Court were therefore in error in holding that the appellant had failed to comply with the requirements of section 16C of the specific relief act, and the appellant must be held entitled to a decree for specific performance of contract in the suit filed by him. We find that the possession of the land was so and so, and then having regard to the depreciation of so and so, only this amount was. But in our case, we have already deposited. In this case, it was not. Last case, absolutely directly identical facts. Therefore, I am placing this. This is 2012, volume 5 SCC. Here.
SCC.
2012, volume 5 SCC, page 712. Param. This I may be allowed to place in detail because, Your Lordship, what had happened in this case was that in our case also there is total denial of the agreement. The defendants who have appeared, the subsequent purchasers, they have appeared and have challenged the existence of the agreement itself. And in this case also identical set of facts were there. Para 3 Your Lordship may see, because I will place first facts and then. In the joint written statement filed by the appellant and his father, the locus standi of so and so was questioned on so and so. On merits, this is important, on merits it was pleaded that the appellant's father, who was about 88 years old and was sick, had not executed the agreement, and the same was a fictitious document prepared by the respondent in collusion with Colonel so and so and with the Bhardwaj. The appellant and his father denied the receipt of earnest money and offered so and so. Then para 6 Your Lordship may kindly. However, the trial court declined the relief of specific performance by observing that the price of the land had considerably increased and it would be unfair to compel the appellant to execute the sale deed at the rate agreed to by the parties, and then he relied on so and so. Then para 7. The respondent challenged the judgment and decree of the trial court by filing appeal. The appellate and his father did not file an appeal for cross objection to challenge the finding recorded by the trial court on issues of execution of the agreement and readiness and willingness on the respondent's part to perform his part. The lower, then Your Lordship, it granted. Para 8 it said that lower appellate court reversed and it granted the decree. That is it has been mentioned. Then para 10. Mr. J. Gupta so and so, after 3-4 lines, the learned single judge of the High Court, this is submission, Your Lordship. The learned single judge of the High Court committed serious error by
You
approving.
just
This is only a submission.
कोई
Of,
बात नहीं, submission कर दिया.
yes, the learned single judge of the High Court committed serious error by approving the same, ignoring the respondent had neither pleaded nor there was any evidence produced to prove that it had sufficient financial resources to pay the balance amount. The learned senior counsel emphasized that the respondent was not only required to specifically plead but also prove its readiness and willingness to pay the balance price, and the lower appellate court was not justified in granting the decree of specific performance merely because the respondents had produced the evidence to show that its representatives have offered 9 lakh to the appellant's father. Sri Gupta further argued that so-called refusal on the appellant's father to receive
That's
9
not
lakh and hand over the possession.
That's not right.
Yes. Then para 14, Your Lordship. We have heard the respective submissions. A reading of the agreement executed by so and so reads as follows. Then how this amount was to be paid has been mentioned in 14.3. It was in several steps this amount was to be paid. Then paragraph 15. The question, now in this case, Your Lordship, I'll pause. Only initial amount was 1 lakh and next amount installment was required to be paid was 9 lakh, and then several amounts were required to be paid. But here the question, what the Honorable Court said, the question whether the respondent was ready and willing to perform its part of the agreement is required to be decided in the light of pleadings of the parties, evidence produced by them and their conduct. In paragraph 5 of the plaint, the respondent categorically pleaded that it was always ready and willing and is still ready and willing to perform its part of the contract. And on 22/11/1996, rupees 9 lakh have been offered to the appellant father, but the latter refused to accept the said amount. The thrust of the case set up by the appellant was that his father had neither executed the agreement nor received the earnest money. According to him, the agreement was an end product of criminal conspiracy hatched by the respondent with the help of Colonel Harjit Singh and so for defrauding him. The appellant also pleaded that the agreement relied upon by the respondent was a fake and fabricated document. In reply to the averment contained in paragraph 5 of the plaint, the respondent was always ready and willing and is still ready and willing to perform his part of the contract. The following statement was made in the written statement. The paragraph 5 of the plaint is wrong and therefore denied. The question of readiness and willingness on the part of the defendant does not arise at all. The question of receiving a sum of rupees 9 lakh does not arise at all. The trial court comprehensively analyzed the pleadings and evidence of the parties and held that the respondent had succeeded in proving the execution of the agreement by the appellant's father and receipt of rupees 1 lakh by him. The trial court then considered the question whether the respondent was ready and willing to pay the balance amount and observed. Your Lordship may skip to only after last 4 lines of that paragraph. The defendants are also stopped from taking a plea that this was the observation of the trial. Then Your Lordship, para 90. The learned single judge also considered the issue of readiness, willingness of the respondent to perform its part of the agreement and observe. May I read the entire one? Yes. Last 5 lines of before paragraph 20 here. The respondent plaintiff had demonstrated his willingness to pay 9 lakh on 23 so and so by placing on record demand draft of so and so in favor of the appellant. However, as noticed above, since the appellant refused to accept the same, the respondent was prevented from performing its part of the agreement by offering money for execution of the sale deed on subsequent dates. In our view, the concurrent finding recorded by the trial court and the lower appellate court on issues of execution of the agreement by the appellant's father and the respondent's willingness and willingness to perform its part of the agreement were based on correct evaluation of pleadings and evidence of the parties, and the learned single judge of the High Court did not commit any error by refusing to upset those findings. The argument of the learned single counsel for the appellant that in absence of specific pleading about continued readiness and willingness of the respondent to perform its part of the contract of the agreement and availability of the fund necessary for payment of the sale consideration, the High Court should have set aside the concurrent finding recorded by the trial court below sounds attractive, but on careful scrutiny of the record, we do not find any valid ground to entertain the same. Then, para 22, after 5-6 lines, to adjudge, no, I'll skip that. Same thing has been repeated in para 22. Then, para 24. It is significant, this is the most important. It is significant to note that the appellant and his father had set up case of total denial. They repeatedly pleaded that the agreement for sale was a fictitious document and the respondent had fabricated the same in connivance with Colonel so-and-so. However, no evidence was deduced by the appellant to substantiate his assertion. That apart, he did not challenge the finding of so-and-so. Then, para 26. In the present case, the appellant had neither pleaded nor hardship nor any so-and-so.
The trial court has recorded readiness and willingness in your case.
Yes, yes.
The appellate court has not returned any finding.
It has said that that question is not required to
Not
go on.
required to be answered.
So that it has not upset that finding. And here is a case, exactly identical case was there, where they also had said, denied the agreement in toto, and both the courts have concurrently held that the agreement is valid.
Here we have, the agreement is valid, there is no doubt on that.
So
There is no substantial question of law on that.
no. I say that this judgment actually fits the entire. So if a person denies the agreement in toto, then he cannot this particular capacity to pay readiness and willingness.
That is an alternative.
And in this, your lordship would find that readiness and willingness was actually controverted in the written statement. In our case, absolutely no. So this is my submission. Therefore, my submission would be that once they denied the agreement itself, and that was found to be genuine, and it was proved, then
The learned counsel has relied upon the judgment passed by Honorable Supreme Court reported in bracket 2012, bracket close 5 SCC 712, paragraph 24, and has submitted that as in the present case, in the judgment before the Honorable Supreme Court also, there was a complete denial of the agreement of sale, rather it was alleged to be forged and fabricated. But the finding in connection with the agreement of sale was found to be valid and was decided in favor of the plaintiff. He submits that in a case where the defendants have totally denied the very existence of the agreement of sale, the matter has to be looked into slightly differently.
this is all, because he has one judgment, only he may be allowed to place that, because he has searched it out, don't want to take maybe.
क्या judgment है?
My senior has already argued on all the points of facts are law and law. So only try to satisfy the Honorable Court in respect of what would be the consequence if readiness and willingness is pleaded, it is deposed, and that stood uncontroverted. I am relying upon only one judgment of the Honorable Supreme Court.
The learned counsel, उनका नाम लिखिए. In addition to the arguments advanced by Mr. Rahul Gupta, has submitted that the consequence of specific pleading of readiness and willingness and specific deposition of readiness and willingness by the plaintiff, which remained uncontroverted not only in the written statement but also during cross-examination of the plaintiff who was examined as PW19, is to be seen in the light of the judgment passed by the Honorable Supreme Court reported in bracket 2023, bracket 4 SCC 239, para 12, 13, 14 and 16.
I am permitted to read from para 12. At the outset, it is required to be noted that the trial court on appreciation of evidence on record specifically recorded findings on readiness and willingness on the part of the plaintiff to perform his part of the agreement. The findings recorded on readiness and willingness on the part of the plaintiff were on appreciation of the entire evidence on record. In the legal notice, which was issued on 20/11/2017, the plaintiff asked the defendant to receive the balance amount and execute the sale. In reply to this legal notice, the defendant denied the execution of the agreement to sell it. That thereafter, the plaintiff filed a suit for specific performance, in which it was specifically assured that he was ready and willing to perform the agreement dated so as to. In his deposition, the plaintiff specifically stated that he was ready and willing to perform his obligation under the agreement. He further stated that he approached the defendant in the month of June 2007 and again in July 2007 with the balance consideration. There is no cross-examination in this regard. The plaintiff also examined two witnesses so and so, who specifically stated that in July the plaintiff approached the defendants and asked them to accept the balance sale consideration in cash. To that, there is also no cross-examination. The receipt of rupees 3 lakhs by way of earnest money has been held to be proved by both the courts. Within a period of 1 month from passing of the decree, the plaintiff deposited the balance sale consideration that is 9,74,000 before the learned trial. Considering the aforesaid facts and circumstances of the case, it is observed that the High Court has materially erred in reversing the decree by reversing the findings of the trial court on readiness and willingness of the applicant. Thereafter, however, there is a reference to a judgment passed by the Honorable Supreme Court in Ramrati Kuwar, which has been taken care of in the next subsequent paragraph, that is paragraph 16 on the subsequent page. In Indira Kaur, this court, after considering the observations made by this court in Ramrati Kuwar, has set aside the findings recorded by 3 courts below, whereby an adverse inference has been drawn against the plaintiff therein for not producing the passbook and thereby holding that the plaintiff was not ready and willing to perform his part of the agreement. It is observed, this is important in the option. It is observed and held that unless the plaintiff was called upon to produce the passbook, either by the defendant or the court orders him to do so, no adverse inference can be drawn. But this is my submission, that no adverse inference can be drawn in view of the fact that he has not been cross-examined on the capacity or having the availability of funds.
The learned counsel
Perform
has
the
submitted that the statement in the plaint and the statement made in evidence of PW19 clearly stated his readiness and willingness to perform his part of the contract. And there was neither any cross-examination on the point, nor he was asked upon to show the availability of fund. He has also submitted that the conduct of the plaintiff is also required to be seen, as was seen in the judgment of the Honorable Supreme Court in the case of Basav Raj, that the balance consideration amount was immediately deposited by the plaintiff in the court after the decree passed by the learned trial court. The learned counsel has submitted that although much time has elapsed, but the fact also remains that the balance consideration amount was duly deposited by the plaintiff and the same is still lying with the court. And therefore there is no equity in favor of the respondents, merely because there are sale deeds in their favor and the agreement of sale is of the year 1970.
I'm permitted to raise one more issue, whether this honorable court in the second appellate
लेकिन जो
stage,
चीज़ आपके फेवर में समझ आता है किसी भी काउंसिल के फेवर में वो हम अपनी तरफ से लिखा देते हैं, इससे ज़्यादा तो आप नहीं बोल पाइएगा. चलिए और क्या बोलेंगे?
whether this second appellate court at this stage would like to enter into the contentious issue of readiness and willingness when the entire
Once you see, trial court gave a finding. The appellate court, while reversing the decree, refused to
upset the
the मतलब refused to decide the point. So कहीं तो decide होगा ना भाई. उसका क्या consequence है? आप substantial question of law बना दिए हैं, अपने यहाँ कहानी मत सुनो.
that can be answered in negative as well.
हम कहाँ बोल रहे हैं नेगेटिव में नहीं आंसर कर सकते, सुन किस ले रहे हैं आपको और इतना अभी तक कोर्ट को रीड करने नहीं आया.
It's too early.
People are taking training on body languages also. Are you aware?
What's that?
Advocates are getting trained on reading body languages
No,
also.
we should read mind.
No, body language से mind reflect होता है.
I have never. Why make it?
You can control your, reflections. You can control many things, but body language you can never.
We should be good gamblers.
No, it is not a matter of gambling.
Poker face. You have to put up a face that we don't understand anything.
ऐसा
If you're
humanly
judging-
possible नहीं. अच्छा दो चीज बताइए मुझसे. There was a period of 2 years from the date of the agreement to pay the balance. Was it permissible for the defendant number 1 to execute the sale deed prior to expiry of 2 years?
This time is actually of no consequence.
No,
in
it is a consequence. Suppose I enter into an agreement and say that I will pay you in 6 months' time.
Correct.
And this is how I plan, whatever be my plan, I'll sell my property, get the money. And before that period, 6 months expires, can anybody enter into
I
the
think 2
agreement?
years is the outer limit.
Certainly, that outer limit has to be honored.
Correct. It has to be within. But time has never been the essence of a contract in a remote
In-
property.
You see, please don't argue that. When a 2 years period is given in the agreement of sale, that it will be executed. Suppose he wants to file a specific performance.
He'll have to wait for this.
He'll have to wait for 2 years.
Correct. He'll have to
He
wait.
cannot file a specific performance of contract unless a situation like this emerges.
Language.
Unless a situation like this emerges and the property is already sold. And that is why he has made a statement that I could not wait because the property is already sold.
Correct.
And he filed the suit for specific performance.
He did.
So, ये तो बहुत अजीब, हम इस तरह का जजमेंट कैसे करेंगे?
I'll answer.
Please answer.
Yeah, I'll just have a look at the contract. First is, my learned friends query that in second appeal, Chips have said that answer होगा because
एकदम होगा आंसर. हम
Section-
बनाए हैं, हम जरूर
Section 103 is supporting what your Chips are saying CPC. Just have a look at Section 103. So I don't think there's an error of there would be any lack of jurisdiction for your Chips too.
ऐसा कुछ है ही नहीं. सुन के उनको किए हैं. Wherever with the provision, we will look for it. 103.
103. In any second appeal, the High Court may, if the evidence of on record is sufficient or according to me insufficient, determine any issue regarding the issue necessary for the disposal of the appeal A, which has not been determined by the lower appellate court or both by the court of first instance and the lower appellate court, in my case lower appellate court, which has been wrongly determined by such court or courts by reason of a decision on such questions of law as is referred in section. So your Lordship is well entitled to reapply the entire evidence in terms of section 103. That's the answer. Suji.
Particularly in a case where there is a judgment of reversal.
Correct. More so in the case of reversal. So the question of sufficiency and insufficiency of evidence both will come into play. So according to me, the evidence is on record. Your Lordship have sufficient.
You don't buy that argument. When I have not bought that.
I'm just insisting that there is a scope.
There is
Now
full
coming
scope.
back to the judgment which my learned friend cited, the latest judgment, which according to me is a shot in my arm, it actually takes me back. This judgment of 2023-4 SCC. Now, if your Lordship looks at the facts of that case, which is very important, in that particular case, apart from the plaintiff coming and saying that I have the money, there were two other witnesses who said that I had the plaintiff and gone. Kindly have a look at paragraph.
Had gone and offered
Offered in
and that
cash.
is there.
In
That is
cash.
there. On facts, there
So
is a
they-
distinction.
Now, similarly, this judgment primarily relies upon another judgment of Indra Kaur, which is in paragraph 15 of that judgment. Kindly see paragraph 15 where it is quoted, Indra Kaur is quoted. Fourthly, it is urged that the respondents did not produce any accounts even though their case was that accounts were maintained and that Vaisakhi Singh used to give maintenance allowance to the widows who were necessary. It is urged that adverse inference should be drawn from the facts. Accounts were not produced by the respondents, and that if they had been produced, that would have shown sufficient payment, not of maintenance allowance, but of half share of income of the widows by virtue of their rights to property. It is true that Dwarka Prasad Singh said that his father used to keep accounts, but no attempt was made on behalf of the appellant to ask the court to order Dwarka Prasad Singh to produce the accounts. An adverse inference could only have been drawn against the plaintiff respondents if the appellant had asked the court to order them to produce accounts and they had failed to produce them after admitting that Vaisakhi Singh used to keep accounts. But no such prayer was made. In these circumstances, no adverse inference could have been drawn for non-production of accounts. But it is urged that even so, the accounts would have been the best evidence to show maintenance was being given to the widows act, and best evidence was withheld by the plaintiff, and only oral evidence was produced to the effect that the widows were being given maintenance of Vaisakhi. Even if it be the accounts would be the best evidence of payment of maintenance, then and they had been withheld. All that one can say is that oral evidence that maintenance was being given to the widows may not be acceptable, but no adverse inference can be drawn in absence of the prayer by someone. And if they had been produced, they would have shown the income was divided half. So here where the court says that the evidence but the oral evidence cannot be acceptable, adverse inference cannot. This judgment is a proposition on the authority that you cannot base a finding on adverse inference. So this does not dilute the other law. Now the law is very clear. I do not dispute that there is a pleading, which is less. Para 7 is sufficient pleading. There is no deficiency in pleading. But the pleading has to be followed up by proof. Now in a case of this nature, mirrors, the facts are very peculiar. It goes ex parte against defendant number 1. Defendant us, whom we are representing, have no knowledge of the fact of his readiness and willingness at any point of time. I cannot in my WS for the heck of writing or opposite. Please appreciate that I do not have personal knowledge, I do not have information. So I cannot lie before a court and say that I have knowledge. So I have not denied it. But that does not absolve the plaintiff of proving his case. In an ex parte suit against the defendant number 1, the plaintiffs have to prove their own case. Now kindly come to the 2024 SCC Online 1749, B. Rabindranath, which behind that.
2024.
For SCC Online SC 1749. Paragraph 22. Now, can I just make a small submission before I read the judgment?
You have already placed it.
Yes, I just want to highlight 2, 3. But can I make a submission before your lordship reads that judgment? My submission is both of us are relying on various judgments of the Supreme Court. We all have to understand, and your lordship is aware, that facts of the case have a bearing on the outcome of the.
Certainly.
There are 2, 3 judgments your lordship once I gave that the judgment cannot be read as a statute.
That's right.
But there is something called a declaration of law otherwise in a judgment. That the law has been declared in this manner, irrespective of facts. Now, paragraph 22 actually calls out the declaration of law in this regard by the Supreme Court. It is not fact-based. So kindly have this. Relief of specific performance of contract is a discretionary relief. As such, the courts, while exercising to grant specific performance of contract, need to be extra careful and cautious in dealing with the pleadings and the evidence in particular led by the plaintiff. The plaintiff have to stand on their own legs to establish that they have made out a case for grant of relief of specific performance of contract. The Act 1963 provides certain checks and balances which must be fulfilled and established by the plaintiff before they can become entitled for such relief. The pleadings in a suit for specific performance have to be very direct, specific and accurate. A suit for specific performance based on bald and vague pleadings must necessarily be rejected. Section 16C of the 1963 Act requires readiness and willingness to be pleaded and proved by the plaintiff in a suit for specific performance of contract. The said provision has been widely interpreted and held to be mandatory. A few of the authorities on the point are referred hereunder. In a case of Mankor vs. Hartar Singh Sangha, this court held in paragraph 40, which is reproduced hereunder. A person who fails to aver and prove that he has performed or has always been ready and willing to perform the essential terms of the contract which are to be performed by him, other than the terms the performance of which have been prevented or waived by the defendant, is barred from claiming specific performance. Therefore, even assuming the defendant had committed breach, if the plaintiff fails to aver in the plead or prove that he was always ready and willing to perform the essential terms of the contract which are required to be performed by him, other than the terms of the performance of which has been prevented or waived by the plaintiff, there is a bar to specific performance in his favor. Therefore, the assumption of the respondent that the readiness and willingness on the part of the plaintiff is something which need not be proved if the plaintiff is able to establish that the defendant had refused to execute the seal deed and thereby committed breach is not correct. In U.M. Krishnamurthy versus so-and-so, the following was held in para 46. It is settled law that for relief of specific performance, the plaintiff has to prove that all along until the final decision of the suit, he was ready and willing to perform the part of the contract. It is the bounden duty of the plaintiff to prove his readiness and willingness by adducing evidence. The crucial facet has to be determined by considering all circumstances including availability of funds, and a mere statement of averment in plaint of readiness and willingness would not suffice. See, in the case of His Holiness so-and-so versus Sita Ram Thapar, it was held in paragraph 2. there is a distinction between readiness to perform the contract and willingness to perform the contract. By readiness may be meant the capacity of the plaintiff to perform the contract, which includes his financial position to pay the purchase fees. For determining his willingness to perform this part of the contract, the conduct has to be properly scrutinized. There is no documentary proof that the plaintiff had ever funds to pay the balance consideration. Assuming that he had funds, he has to prove his willingness to perform his part of the contract. According to the terms of the agreement, the plaintiff was to supply the draft sale deed to the agreement within 7 days of the execution of the agreement, that is by so and so. The draft sale deed was not returned after being duly approved by the petitioner. The factor of readiness and willingness to perform the plaintiff's part of the contract is to be adjusted with reference to the conduct of the party and the attending circumstances. This court may infer from facts and circumstances whether the plaintiff was ready and was always ready and willing to perform his part of the contract. The facts of this case would amply demonstrate that the petitioner plaintiff was not ready nor had the capacity to perform.
Primarily, you want to submit that the availability of the fund was required to be demonstrated.
Correct. There is no evidence. Pleading is there. They have not proved any evidence, except for your action pointed paragraph 10 of the PW9. 90. That where he says the same stereotypical thing. He had to stand in the witness.
Please don't repeat your answer.
So that is one.
You just answer this.
Yes.
2 years. How do you respond to that? How do you respond to 2 years period?
Just a moment. Can I just?
एक exhibit 5 का photocopy provide करें.
If I'm right, what it says, I'm just reading it along. अभी करीब 2 साल केवाला
के लिए कलामी तामील होना संभव नहीं है, इसलिए लेख्याधारी से 2 साल का मोहलत केवाला सच कलामी करने के लिए वक्त मांगा। वो 1000 रुपये बजरिए इस एग्रीमेंट हाजा के बतौर जरखाना के मांगा। यह कि लेख्याधारी आज के तारीख में 1000 रुपये बतौर जुर्माना को पाया। यह कि लेख्याधारी के नाम से 2 साल के अंदर केवाला करने कलामी तामील कर देंगे। अगर लेख्याधारी के नाम 2 साल के अंदर केवाला तामील नहीं करेंगे तो लेख्याधारी को अधिकार प्राप्तियार हासिल होगा कि यह लेख्याधारी द्वारा कोर्ट के उपरोक्त संपत्ति को रजिस्ट्री करवा लेवे और वह खर्च अदालत का देकर होवेंगे। यह कि उपरोक्त
टाइप भी करा के देंगे।
हाँ, इसका वर्ड टाइप
नहीं, वो करा नहीं। आप उनको 2 साल का एक्सप्लेनेशन दीजिए।
2 साल। The agreement, as it appears to, it clearly said that it is not possible to execute for them a sale deed within the period of 2 years. Now, for the next 2 years, 1,000 rupees is being given, and he is not taking that.
If he does not execute the
within
agreement,
2 years, then he will be entitled to money.
how did you sell the property within
No.
2 years?
Yes. Number one, this, according to me, does not contain a negative covenant. Under the specific relief act on a contract, there has to be a negative covenant for forbidding me for the time not to deal with the property.
So you can do anything like that.
I have done. No, not I am not to be. I cannot explain my vendor. Now, in my case also, so far as my case, my learned friend has indicated property ownership, that in my sale deed also, it was indicated to him in my sale deed, and therefore Bonafide are there that I am making part payment now.
Yes, that we are.
So therefore, in both the cases, it appears that the payment was. So in my case also, I am Bonafide
Your
established.
payment was deferred.
Deferred, it was there. Therefore, it is not an afterthought that after the suit was.
That's
used-
right. That we are.
That,
You
So-
explained 2 years.
2. Now 2 years it only.
Because as per section 16,
Yes.
parties are bound by the contract.
They are.
And therefore, any clause of the contract cannot become redundant by the act of the
I'll
parties.
just indicate. Kindly come to section
16.
no, not 16.
Essential terms of contract. It is the essential terms of contract. Whatever be the essential
Section
terms.
42 minutes of the specific. That's what I'm saying.
Yes.
Now section 42. Notwithstanding anything contained in clause E of section 41, where a contract comprises an affirmative agreement to do certain act, coupled with a negative agreement, express or implied, not to do a certain act, the circumstances that the court is unable to compel specific performance of affirmative agreement shall not preclude it from granting an injunction to perform a negative covenant. Provided pleading. Now here negative, it had to be coupled with a negative covenant. I will not do. That is,
The answer is not satisfied.
but here was that to bind me, bind not me, not the vendor. To bind the vendor, I cannot step into his shoes. But this again is a
And
document.
just see the conduct of the vendor.
That is what I'm not.
You have requested her to come and depose. She refused.
Because she is in a.
No, what is this?
But she is in a win-win situation every time.
Win-win?
She's in a
A
win-win situation.
fraudulent person completely.
But that will not take away mine.
Yes, that we have to see.
Yes, my
Whether
interests are
whose right it will be taken.
taken away. Whose rights have to be taken away?
That's
Whether the plaintiff is
Can you
equally.
claim any equity after such passage of time?
Yes, most certainly. In the
No,
case.
because they have already deposited the amount and it is lying with the court since
Oh,
1988.
that is not relevant. That is not relevant. That deposit is not relevant. Kindly have a look at this judgment. UN Krishnamurthy only. That is not relevant. Para 46. Para 46 on this point, but subsequent deposit. Para 46 of
Subsequent deposit means?
after the decree of the court is of no consequence. That is what the Supreme Court has said in 2023-11 SC.
Otherwise, so basically we have to see the basic ingredients irrespective of the passage of time.
Irrespective. So now, after the decree is passed, you deposit the money. Nothing. You don't gain any advantage out of it. That is what the Supreme Court has said. That is not a proof, sufficient proof. Paragraph 46, if your lordship kindly notes on that point of UN Krishnamurthy on subsequent 2023-11 SCC
Yes.
77.
Para number?
Para 46 minutes. Para 46 in the middle there is a 2003 and then your lordship will say making subsequent deposit.
After lapse of 7 years.
And then उसके बाद है Reliance may placed on Umabai versus so-and-so wherein this court speaking through his vicinity and the deposit of amount in court is not enough to arrive at a conclusion the plaintiff was ready and willing to perform his part of the contract. Deposit in court would not establish plaintiff's readiness and willingness within the meaning of section 16C of the specific relief act. The relevant part of the judgment is reproduced below. Deposit of any amount in court at the appellate stage.
This is absolutely irrelevant.
Sorry?
It is irrelevant completely.
No, I am only saying that the subsequent deposit is of no help even during the proceeding before a decree is passed. After a decree is passed, you are filing because you want to enforce it. That is of no consequence. That does not. But his money is deposited. He should get it back with interest if you don't. But the point
Who will
here
get the
is
interest?
section 19.
Who will pay the interest? It is lying in the court.
Yes. It is
Yes.
the court had to keep it in a interest bearing account.
Don't forget the court might.
But that is something he has done in execution of his decree.
That's right.
That is something which is done in execution of the decree. That is not, I am not to be liable of made for. The point is then goes back to section 19, which your lordships have framed that substantial question of Bonafide, purchaser without notice.
No, that we have already recorded. You
So,
don't need to
yes,
repeat on
I am
that.
not repeating. So, your lordship, even if your lordship feels that there is this 2-year agreement period is not sufficiently satisfying answer has been given, because I am, that minutes, therefore, I am saying that a contract, the terms of the contract also have to be proved if we go by law. It's a question of fact. Terms of the contract is a question of fact. Now, in absence, I don't know, I'm so sorry, but there is nothing in the evidence which shows that this was proved. This fact was proved, and since the defendant number 1 did not appear, how it was sufficiently proved. Merely a contract clause being there, the terms of the contract do not stand proved. It has to be proved. I don't see it.
The learned counsel for the respondents has responded to the terms of the agreement, which provided that the sale deed was to be executed in favor of the plaintiff within a period of 2 years, failing which it was open to the plaintiff to get it executed through the process of law. And in the present case, admittedly, the sale deed was executed in favor of defendant number 2 and 3 much prior to the expiry of 2 years. He has submitted that the terms of the agreement was also required to be pleaded and proved, and further he has referred to section 42 of the specific Plaintiff Act 1963 to submit that. Bas khali 42.
And I'm sorry, but I don't think that the agreement has been proved. Which is the signature? I really need to check. Exhibit 5 is by the plaintiff.
Exhibit 5 is the agreement.
Let us see whether the contents have been proved or only the signature. Because mere proof production of the document does not mean contents have been proved.
Okay.
So what the law is,
there is specific averment in the plate also, that it will be done within 2 years.
6 Mahadeva. He has drafted the document. He has drafted the
that's
There is
what-
specific averment in the plate also.
Let us see what's the again. Who is proving it? It is being proved by the person who typed it or drafted it, not by the signatory. So the proof of the terms and the conditions have to be specifically proved that yes, this one.
The learned counsel has submitted that the terms of the agreement has not been sufficiently proved, and therefore the same cannot be used against the defendant number 2 and 3. That's all.
Just give me a minute. Let's just.
एक काम करेंगे, W6 का UDC करके टाइप करके
Because the parties to the agreement have not proved the contents.
Party is not appearing.
No, the plaintiff also.
Plaintiff has stated.
He has stated, but in his evidence he has not. That's what I'm saying.
He has stated.
No,
He stated in the evidence also.
in evidence, what he has said is only this paragraph 7, PW19. Kindly come. What I'm trying to say that every then fact has to be proved. The agreement as a whole or a part of it has to be proved. So paragraphs 5 itself. एक बार paragraph 6. Now, in fact, it goes against what my learned friend is saying. Paragraph 10 of PW19. This is not the case set up by the plaintiff in his evidence that there was 2 years' time and before 2 years he has sold the property. Hence, I am bringing in this suit. He has in fact said in paragraph 10 that I was all along competent. In fact, in the legal notice also, Manoj, this is not the case which has been set up. That you had given me 2 years time and before that you could not sign. So this merits we consider this is not a case set up by the plaintiff.
I have read. That's all.
Yes.
Concluded, post for judgment on next Monday or on any other date as may be notified by this court, whichever is admitted.
Your Lordship could
Monday
kindly
tak
record,
pari jayega.
kindly record that submission or that they have not. The pleading also.
The learned counsel
I have
has
said
submitted
and-
that with respect to the 2 years period as referred to in the agreement, there is neither any foundational pleading nor any evidence.
Rather, Manoj, the case is contrary. That the 2 years period because there were no he was given to them. Rather, she says that I was all along ready.
Rather, the case is contrary. The plaintiff has stated that he was all along ready and willing to pay the remaining consideration amount. Even in the legal notice, he stated that he was ready and willing to pay the balance consideration.
So the 2 years was understood not to be mandatory. That is all. The intention of the parties. Acha, 81 se possession pe that equitable consideration is a must. 81 from 81 I am in possession. And it's a residential house.
Salutation this will be Jharkhand. Saurabh has been working on this file. UP-6 file. चीजें बहुत इंटरेस्टिंग है जितना लेयर खोलिए उतना कम सिविल लिटिगेशन में आप आपको एग्रीमेंट की कॉपी देंगे PW6 का एविडेंस देंगे और क्या चीज़ एक और क्या agreement का
PW2 has proved he is the draftsman. PW6 is the advocate.
अच्छा,
PW19 is the plaintiff himself.
who has proved exhibit
But all the three have stated that
इसमें PW2
is the Ajit Kumar Sinha. He is the advocate.
and PW6
6
ये दोनों relevant हैं
relevant.
PW2 और PW6 का evidence
And the agreement copy.
agreement ये रिकॉर्ड से नहीं निकाल पाएंगे सर्टिफाइड कॉपी से फोटोकॉपी अभी करवा के दीजिए अब जजमेंट मंडे कमिंग
Item 1 offense second up to CT7 of 1997.
Who is there in this case?
I am appearing in the judgment of reversal. We are the original plaintiff. And we have filed the suit with a prayer for the occupancy right and possession over the suit land and be declared and confirmed. And thereafter, there was one prayer for the temporary injunction. But look, lower
This
court
is covered by Ugni Devi.
mine.
Let us. Ugni Devi has been considered.
No, that has not been. The trial court, though it has not been considered, but on the same ratio, the order judgment has been passed. And first appellate court, he has gone to a different presumption that we have not pleaded that the return has been filed, we have not brought on record that a return has been filed.
What is the oldest rent receipt? You have.
That
What
we
is the
have
date of hukumnama? Hukumnama was exhibited.
that has been exhibited.
Exhibit number.
That is exhibit number 2.
Exhibit 2. Has it been held to be forged and fabricated?
No.
Is there any finding that it is forged and fabricated?
That there is no finding of the trial court.
And what about the appellate court?
The appellate court has not said. He said कि ये अगर ये issue हुआ होता then return file करना था, return file करके
वो अलग बात है.
forged and
Is-
fabrication के लिए
No
नहीं,
finding on
no
forged
finding.
and fabricated. I will go through the judges, please go.
And the jamindari rent receipt that has also been exhibited, that is 1/A, and thereafter the state of Bihar rent receipt.
Zamindari
Rent receipt that has also been exhibited
exhibit
1/A.
1/A. What
And
is the
exhibit-
date? Date. And what is the date of hukumnama?
Hukumnama is of Magha Samvat 2021, 2001. That is 1944.
Mark Samvat 2021.
2001, sorry.
2001.
One.
Equivalent to 19.
ये 1944 चला जाएगा, 57 साल कट जाता है.
40. Okay. All right. जमींदारी रेंट रिसीट का डेट क्या है?
जमींदारी rent receipt.
Don't pray for time. Time नहीं मिलेगा.
पास
पास ओवर आप सुनिए ना, आप लिखिए. पास ओवर तब तक आपके वकील साहब आ जाएंगे.
कैट
हाँ,
कैट
बहुत अच्छी बात है. उनको बोलिए कैट में रहने. हाई कोर्ट में टाइम लेते हैं कैट जाने के बहाने. Very good. कोई बात नहीं. Your senior is not required. आप तैयार हो जाइए.
2010.
Rent receipt is
रेंट रिसीट का जो
1 to 1/A. Exhibit 1 to 1/A. हुकुमनामा 2 क्यों एग्जिबिट हुआ है? हुकुमनामा X फॉर आइडेंटिफिकेशन है.
हुकुमनामा हमारा है वन सीरीज रेंट रिसिप्ट है, 2 है सादा हुकुमनामा जो मेरा है. दूसरा हुकुमनामा लेके आए होंगे कि जो अदर पार्टी है, अपोजिट पार्टी, वो भी जो है मेरे को-शेयर से एक पार्ट ऑफ द लैंड खरीदे थे बाय दैट हुकुमनामा. दैट इज नॉट ए सूट लैंड.
ये रेंट रिसीट कब का है?
रेंट रिसिप्ट मतलब नीचे लिखा है मार्क 2010. इसमें 2006, 7, 8, 9 और 10.
This is the only rent receipt you have?
Thereafter, my lord, the rent receipt issued by the state of Bihar, that has also been exhibited. That is exhibit 1.
Exhibit 1.
जी. 15/2/63 का है.
Who is the executor of the hukumnama?
The intermediary jamindar who happens to be a father. जमीन टाण लैंड था, उसको हम खेती के लायक बनाए 2.5 एकड़। देन हमसे जो है जमीन हमको हुकुमनामा दिया गया, हमको रेंट रिसीट मेरे लिए इसको दिया। आफ्टर वेस्टिंग स्टेट ऑफ बिहार जो है वो भी हमको इसको एक्नॉलेज करके रेंट रिसीट मेरे इशू करना।
It also contains a revenue stamp.
जी
उसके बाद आपका रेंट रिसीट चलते रहा।
जी उसके बाद
कॉज ऑफ एक्शन क्या था?
कॉज ऑफ एक्शन क्या है? ये लोग जो कहे कि जब पार्ट ऑफ द लैंड जो मेरा लैंड है ये बंदोबस्ती सरकार से कराया 75-76 में, और उसके बाद वो लोग 82 में उसका कब्जा लेने आए तो 144 हुआ, कन्वर्ट किया गया 145 में, 145 ड्रॉप कर दिया गया, कोई जजमेंट पास नहीं किया। देन 1991 देन वी फाइल्ड दिस सूट, दैट इज द कॉज ऑफ एक्शन। अब अपलेट कोर्ट जो है प्रिजम्पशन पर चले गए कि चूंकि मेरे फादर थे इसलिए हमको इट वाज नॉट इन सॉलिटरी गिवन टू मी। जो
रिटन स्टेटमेंट
that is the replica has taken in the trial court judgment। हम लोग ट्रायल कोर्ट जजमेंट से पढ़ सकते हैं।
ठीक है, पढ़ ये चाहिए हमको, बाकी इसको
इतना ही नहीं, जो इनके जमीन पे बंदोबस्ती हुई थी उसकी चौहद्दी नहीं थी, एक सूट का लिए इशू फ्रेम किया गया, एंड दी बोथ द फाइंडिंग ऑफ बोथ द कोर्ट्स आर कंकरेंट कि जो सूट जमीन की चौहद्दी हमने लिखी है वो चौहद्दी एग्जिस्ट करता है, जो अपोजिट पार्टी का है डिफेंडेंट रिस्पोंडेंट का है उनका एग्जिस्ट नहीं करता है। प्लीडर कमिश्नर भी बहाल हुए थे सूट में, एंड प्लीडर कमिश्नर का रिपोर्ट सो फार एज द डिमार्केशन ऑफ द लैंड, द डायमेंशन ऑफ द लैंड, दैट इज इन माय फेवर।
you plead the plaintiff's case
from the judgment. This suit has been brought by the plaintiff Sri Satyanarayan Jha against the defendant for declaration of the occupancy rayati right over the land detailed in the schedule appended to the plaintiff, and also for the confirmation of the possession of the plaintiff over the same. The plaintiff case is as pleaded in the plaint is that the land of plot number 1361 khata number 58 of village Chaudhary Bang stand recorded at Gail Marua Khas having area of 8.51 acres which was khas possession of the intermediary landlord Amarpan Jha who was managing the affairs of jamindari. This Amarpan Jha died leaving behind his 3 sons Alkupan Jha, Manikpan Jha and Mathurapan Jha, out of whom the eldest brother Aklupan Jha, father of the plaintiff, was managing the affairs of jamindari. Out of these 3 brothers, Mathurapan Jha died peacefully, and the Manikpan Jha has one son who is performer defendant number 9 in this suit. The land wherein had possession of the Jha landlord. As such, the plaintiff started reclamation of the land for paddy cultivation within the plot number 1361 from its southern
सब्स्टिट्यूशन वगैरह हो चुका है ना?
जी सब
चलिए।
from the southern side and reclaim about 2.50 acre of the land which is the suit land
एक
for
सेकंड, इसको जरा खोलो। हाँ बताइए.
Phase 2.
हाँ, केस ऑफ रेस्पेक्टिव पार्टीज पढ़ के इश्यूज पढ़ेंगे और सीधे फाइंडिंग पढ़ेंगे. चलिए.
Southern side, I got it. Page
हाँ,
number
हाँ,
पर.
हाँ.
Southern side and reclaimed about 2.50 acres of land, which is the suit land. Further, the case of the plaintiff that the landlord confirmed a status of occupancy right of the plaintiff over the suit land, accepted the rent and in confirmation of the settlement granted hukumnama Magha Sudhi 10 Samvat 2001 VS in favor of the plaintiff. Other co-heirs were also in possession within the plot as such. At the time of vesting of the jamindari under provision of Bihar Land Reforms Act, no land of this plot vested in the state of Bihar, which it bought out of the sale deed dated 9/9/68, obtaining by the defendant number 1 from Kali Charan Jha, one of the co-heirs, landlord for the other vacant portion. The plaintiff has further pleaded that land is in possession of any of the co-heir intermediaries shall be deemed to have been settled with them. The plaintiff being co-heir intermediary converted the land settled with him in 7 kiaris. Besides, some party portion lies on the flank of the paddy kiaris. The plaintiff also alternatively claims as being the heirs of the other landlord, heirs of the landlord. Further, case is that the defendant number 1, who is a railway employee, has assembled with wealth by dubious means and managed to get a sale deed dated 9/9/68 from one Kali Charan Jha, defendant number 9, son of the Manik Panjha, one of the co-heir of the plaintiff, and was also look after to get the suit land as well belonging to the plaintiff, and by any means fair or foul, and as such his hitchman and co-employee wanted to forcibly occupy the suit land reclaimed by the petitioner, which is the reclaimed by the plaintiff, which the plaintiff resisted and resolved the proceeding under section 144 CRPC on 1/12/82, which was later on converted into 1 under section 145 CRPC on 27/1/83, being case number 928 of 1982. During this proceeding, it transpired that when the defendant number 1 has failed in his attempt to get the deed transferred from the suit land, he managed behind back and beyond the knowledge of the plaintiff with the help and connivance of the lower echelon of Revenue Department to get a scrap paper named settlement paper in the name of defendant number 2. He is wife of defendant number 1, dependent on her husband for imaginary party piece of land. Further, case is that during the proceeding, defendant used the aforesaid settlement paper for lying false claim over the suit land, knowing full well that they have themselves acquiesced the acquisition of the royalty right of the ex-intermediary as soon as the defendant number 1 got a sale deed from pro forma defendant number 9, and eventually the circle officer Bagodar has no authority to make any settlement in plot number 1631, Khata number 58 of Mauja Chaudhary Ban. The collusion of the alleged settlement paper is apparent from the fact that defendant number 2 was not a raya and was dependent upon the husband defendant number 1, and not a landless nor a suit land was vested land belonging to the estate of government. The policy of government was to make settlement to any vest land primarily to the member of scheduled tribes, the scheduled caste, and if there is no such person, then to any other person, but with the approval of the deputy commissioner. Further, case is that the aforesaid settlement was of imaginary land. Hence, the defendant tried in vain to confuse the identity of the land. Got commissioner appointed who did not find any land as claimed by the defendants. and filed petition for the substitution of the boundary according to their whims, which was rejected, and revision thereon being criminal revision number such and such was also rejected. Further case of the plaintiff is that aforesaid case number 928 of 82 came to the file of Sri S.G.S. Munda, executive magistrate, who without appreciating the law and the fact over stopped the notice under section 145 CRPC and made out different case, and with an observation that none of the party could prove their right and possession, dropped the proceeding under section 145 CRPC on 11/3/1991 along, although the plaintiff is continuing his possession over the suit land. This transmission of the proceeding in such an unusual manner has casted a cloud on the right and title of the plaintiff, and therefore this necessitated this suit. Further case of the plaintiff is that, being emboldened, the defendant are bent upon to change the nature of the chiaris and demolish the rees, and then therefore to maintain the identity of the suit land, temporary injunction is necessary. The plaintiff further pleaded that cause of action for the suit arose on 11/3/91 when Sri G.S. Munda, the learned executive magistrate, Giridi, dropped the proceeding and continuing thereafter day to day. On this strength of the above pleading, plaintiff claimed the following reliefs. The plaintiff occupy Rayati right and possession over the suit land be declared and confirmed during the pendency of the suit. Defendant number 1 to 8 be restrained by issuance of temporary injunction from changing the nature of the suit and demolish the reeds thereof, and from dismissing the plaintiff from the suit land upon the degree the same may be made permanent. In case the plaintiff is disposed of and during the pendency of suit, has possession be given to the plaintiff the cost of the suit award. Summons were issued to the defendants in this suit, and in response to which defendant number 1 and 2 appeared in one set, filed their WS. Defendant number 3 to 8 appeared in another set and filed their WS, and performa defendant number 9 appeared separately and filed his WS, out of which defendant number 9 has fully supported the claim of the plaintiff in his WS. Defendant number 1 and 2 and defendant number 3 to 8 have contested the suit. The case of defendant number 1 and 2 as pleaded in their WS is that the plaintiff has no cause of action for the suit and it is not maintainable, and this is barred by the limitation adverse possession waiver. The suit is grossly undervalued and the court fee paid is insufficient, as the present market value of the suit land cannot be less than 25,000. These defendants have admitted that land of plot number 1361, khata number 58 has been recorded as Gaj Maduria, having an area of 8.51 acres. They have further pleaded that it is incorrect to say that the Jha land lord were in Khaj possession of the suit plot, and the plaintiff started reclamation of the suit land for the paddy cultivation within that plot from the southern side of the boundary under his plot more or less 2.5 acres of the land. That Aklu Panjha was managing the affairs of jamindari for, and on behalf of two brothers, they have pleaded that actually the plaintiff did not reclaim any portion of the land from the southern side of the plot, covering the area of 2.5 acres, and description given in the schedule of the plaintiff are incorrect, imaginary, and land of this description does not exist on the spot plot number 1361. They have further pleaded that plaintiff with ulterior motive has not disclosed the period up to which the Jha landlord was in possession of the plot number 1361 or part.
The defendant number 1 is claiming it by way of a registered sale deed of 1968.
No, registered sale deed of 1960, that is a different land. Total 8.5.
That is a different land.
That is the different land. वो लेकर के हम लोग आए थे, हम लोग लेकर के आए थे कि वो जो लिए उसके बाद वो मेरे लैंड को इनक्रॉच करना चाहे. जब नहीं हुआ तो 144 आया. देन हुआ कि एक पुराना जो है जब ये सेटलमेंट लेकर के ना सेटलमेंट में कोई चौहद्दी नहीं लिखा. दैट माय लॉर्ड विल गेट, क्योंकि ये भी कहते हैं कि जो मेरा सूट लैंड है वो imaginary है. Though this on this issue, whether it is imaginary or not, both the court are concurrent.
Okay, let us see the issues at page 8. आप जब पढ़ रहे थे तो हम पढ़ लीजिए.
जी. Page number 10.
पेज नंबर 9 में है issues.
9 में इशू था उसको
अच्छा,
रिकास्ट किया गया है.
ठीक है, बताइए.
इसमें इशू नंबर 3 and 4. These are the important issues. Is the description of the land given in the schedule of the plaintiff correct, or it is imaginary, or does there exist any land in plot number such and such?
This is concluded. It has got nothing to do with the substantial question of law.
नहीं, substantial question of law नहीं है, लेकिन ये
Substantial question of law किससे related?
where there is a settlement of the suit land in the favor of the plaintiff by ex landlord, and did the plaintiff become a rayat on the vesting of jamindari. ये 3 इसलिए कहे माय लॉर्ड कि चूंकि उनका प्लीडिंग था जो इमेजिनरी पर, उस पर जो इसी पर प्लीडिंग प्लीडर कमिश्नर का ही बहाली हुआ था, एंड रिपोर्ट वाज इन माय फेवर. फाइंडिंग्स में आते हैं
एक एक इशू का.
पैरा पेज 12 पैरा 30.
I'm having very high fever. पढ़िए.
पैरा 30.
पैरा 12 बस इशू नंबर 1 का क्या?
ठीक.
एक करके एक इशू का फाइंडिंग.
जी. नो एविडेंस
प्रॉपर्ली वैल्यूड हो गया. बात करता हूँ. इशू नंबर 3.
इशू
पैरा
नंबर
13.
3 ये थोड़ा सा पढ़ देते हैं माय लॉर्ड, बिकॉज़ दिस विल गिव सेम फाइंडिंग आया है, ये गवर्न करेगा हमारा इशू नंबर 4.
अच्छा ठीक है, पढ़िए.
On
फाइंडिंग
the-
खाली पढ़िए. पैरा 15.
पैरा फाइंडिंग इशू नंबर 3, ये पैरा पेज 19 पैरा 13 और 1 है. Therefore पैरा 15.
पैरा 15.
जी. Therefore, the documentary evidence of both the side and oral evidence given and gives an impression that the description of the suit land given in the schedule of the plaintiff estate proved by the evidence of the defendant failed evidence, and the defendant failed to prove the description given by the plaintiff is imaginary and that the suit land is imaginary. Therefore, this issue is decided in favor of the plaintiff, and finds hold that the description of the suit land detailed in the schedule of the plaintiff is correct, and the land of the description exists, and description is not imaginary. But coming to this paragraph, they have also taken care of the defendant's witness, जिसमें वो खड़ा होकर कहते हैं कि पहला कि मेरा जो सूट लैंड है उसका सूट लैंड अपना जो लेकर के आई थी कि उनको जो मिला है
वो अलग ही चीज है.
वो अलग है, उसका चौहद्दी अलग बताती हैं, फिर कहती हैं
सेल डीड भी अलग हो
फिर
गया.
कहती हैं कि हमको इनके सूट लैंड से मेरा कोई मतलब नहीं है. नाउ नेक्स्ट पैराग्राफ जो है दैट इज द इशू, मेन इशू. द प्लेंटिफ केस is that the suit was reclaimed by him into 7 kiaris, and occupancy rayati right over the same was confirmed by the ex-landlord. His alternative case on this point is that he is co-sharer of the landlord and plot number such and such, and as such he holds title over the same, and the plot was in khas possession of the ex-landlord at the time of vesting of jamindari. On the other hand, the case of the defendant is on this point that defendants reclaimed the suit land into 9 kiari of Dhankhet and thereafter same was settled by the state of Bihar in favor of the vesting of Jamabandi. The suit land vested into the state of Bihar. On this point, the plaintiff has proved hukumnama granted by ex-landlord, Exhibit 2 and Exhibit 1 series receipts granted by the ex-landlord and the state of Bihar. Out of these, Exhibit 1 is is dated 12 to 63, which is government rent receipt, and Exhibit 1 by A is a rent receipt granted by the ex-landlord, which is Marha 2010 FS. The
2010 में से कितना माइनस करना?
57 minus.
नाइनटीन 1953.
The learned counsel for the plaintiff submitted that these three documents itself prove that the suit land was settled in the name of the father of the plaintiff by the ex-landlord. Even after vesting jamindari, the state of Bihar accepted the settlement granting the rent receipt Exhibit 1. On this point, plaintiff has stated that in the Khatiyan in Khata number 58, this plot is recorded at Gair Majurua Malik and the
खास मालिक,
Gair Majurua
खास मालिक.
Khas Malik, and the entire plot was in possession of Amarkant Jha, who had three sons, namely Aklu Panjha, Manik Panjha, and Mathura Panjha. And Aklu Panjha used to look after the affairs of jamindari. The plaintiff is son of Aklu Panjha and came in possession of 2.5 acres of the plot. However, the witness is aged about 31 years and his oral evidence on this issue does not help much in deciding the issue. On this issue, defendant has filed government rent receipt Exhibit A series, Parwana, Exhibit C, and CC of the settlement case number such and such. Exhibit D, the admitted position that suit plot has an area of 5.51 acres, out of which defendant number 1 has purchased 4 acres of the land from, though it is written 4 acres, लेकिन ओरिजिनल सेल्यूट जब देखा जाएगा ये 4 कट्ठा से land from Kali Charan Jha. Defendant number 7 has stated that Chupara Pan Jha is the brother of the plaintiff, and he also has land within this plot. This suggests that suit land was in khas possession of the ex-landlord. The plaintiff has claimed that the suit land was reclaimed by him. The report of the pleader commissioner also suggests that the suit land are in 7 kiaris dhan khet, whereas the case of defendant is that he reclaimed the suit land and in 9 kiaris. It is the admitted case that the parties that a proceeding under section 145 CRPC was started between the parties with the regard to the suit land of 1982. But DWs have stated that the reclamation by the defendant started after 10 years after the settlement in 1975, meaning thereby that it started in 1985. But in view of the proceeding under section 145 CRPC being started in 1982, the story of defendant of reclamation of the suit land stands falsified. The defendant witness have given different boundaries of the land reclaimed by the defendants, and the same does not tally with each other. Over and above all the Hukumnama Exhibit 2 and Rent Receipt 1 series clearly proves that suit land were settled in favor of the plaintiff before vesting of jamindari by the ex-landlord, who were in khas possession of the suit land, and state of Bihar also accepted the settlement granting Exhibit 1 after vesting of the jamindari. On the basis of this discussion of evidence made above, I find and hold that the suit land was settled in favor of the plaintiff by ex-landlord and plaintiff become the rayat of
Appellate court. What where is the point of determination? Page number?
एप्लेट कोड में भी जो इशू नंबर 3 है वो मेरे फेवर में ही सेटल होता है. ये पेज नंबर 11 अपलेट कोर्ट का जजमेंट पैराग्राफ 50.
कोई अलग से पॉइंट फॉर कंसिडरेशन इज 13. Whether the improved judgment and degree is fit to be maintained. यही है.
The points of consideration whether the improved judgment and degree is fit to be maintained.
अब कौन सा पैराग्राफ पढ़ेंगे?
इसी का फाइंडिंग्स में पहला जो है इन्होंने इशू नंबर 3 को लिया था और 3 पर अपनी फाइंडिंग दी. फाइंडिंग ये फाइंडिंग भी मेरे फेवर में किया.
पढ़िए.
पेज नंबर 13 के लास्ट पैराग्राफ में. This is the description. Boundary लिखा होगा not.
This is the description.
This is the description of the suit land given by the plaintiff. Apart from that, it also appears from the lower court record that pleader commissioner was appointed by the lower court in connection with the injunction petition filed on behalf of the plaintiff who visited the place support the both of the parties, the plaintiff and the defendant, and he submitted a report which is a part of the record under section order 26 rule 10(2) of the CPC. It further appears that report that advocate of the defendant number so and so, उसके बाद 19 में नीचे लेकर now I under these circumstances boundary के बाद I find no reason to disagree with the finding of the court that plaintiff has established the identity of the land.
Is there any finding that the plaintiff is claiming property different from the defendant?
ये इसमें फाइंडिंग कुछ नहीं है, पर जो इन्होंने लिखा है बेसिकली एक जो 8.5 एकड़ जमीन में 2.5 एकड़ जो मेरा मिला है उसकी बाउंड्री कुछ और है, जो वो मांगे हैं उसकी बाउंड्री कुछ और है. हमारा बाउंड्री जो है वो इंटैक्ट रह गया इवन बाय द प्लीडर कमीशन.
So they disputed the identity of your property.
हाँ कि वो इमेजिनरी है.
Imaginary है, and they tried to establish their own property with their own boundary. They provided the boundary also.
In a settlement they have not provided the boundary, but they have pleaded it, they have given in the WS. Later on by the other witnesses have stated the boundary, and all the witnesses they have deposited different boundary. They don't.
So they could not establish the boundary of the property claimed by them.
And even by the pleaders commission report भी boundary मेरे विषय में कहा, हमने 7 की आई कहा था.
भाई आपका सूट प्रॉपर्टी पर प्लीडर कमिश्नर अपॉइंट हुआ ना.
हाँ.
तो उनके प्रॉपर्टी पे
तो मेरे प्लीडर उनका कहना था कि जो जमीन है वस्तुतः वो मेरी जमीन जो है उसको वो अपनी जमीन कह रहे थे.
Who was found in possession of the
हम आज भी 7 क्यारी बोले थे, 7 क्यारी है, उनका 9 क्यारी था उस सूट लैंड के अपने लैंड को कहने के लिए, उनका 9 एग्जिस्ट नहीं करता. नाउ द पैराग्राफ 20 बाकी जो I come to the finding the court below issue number 4, 5 and 6 which are being taken together for the consideration. This has not been submitted on behalf of the appellant defendant that court below ought to have held the hukumnama and rent to a force fabricated and the same cannot be created by title to the plaintiff. The court below further ought to have held that the suit land including the portion of the suit land vested to the state of Bihar and the plaintiff has or had जी
ये अपने मन से.
ये अपने मन से.
It is nobody's case.
It is nobody's
State
case.
is not a party.
State is not a party.
State is not claiming the property.
State is not claiming the land. और इसी को लेकर के चले
It
हैं.
has been submitted on behalf of the appellant. पढ़िए तो फिर से इसको.
It has been submitted on behalf of the appellant defendant that court below ought to have held that hukumnama and rent received were force fabricated and same cannot be created title to the plaintiff. The court below further ought to be held that the suit land including the portion of the suit land vested in the state of Bihar and plaintiff has or had no title or possession over the suit land. अब ये डिफेंडेंट इसलिए नहीं कह सकते थे माय लॉर्ड कि एक ही 2001 संवत में 2.5 एकड़ हमको मिला, जो जिनसे वो कालीचरण झा खाते थे वो भी कुछ लैंड को उसी खाता प्लॉट में रिक्लेम किए थे जो उनको सेटल हुआ था. एक दूसरे भाई जो जिनका नाम हम पढ़े के झपरूपन झा वो भी कुछ रिक्लेम किए थे, उनको भी सेटल हुआ. सब 2001 में सेटल हुआ था और उसी सेटलमेंट के आधार पर
different persons were claiming property by virtue of settlement in 2001
itself. उसमें है कि सूट प्रॉपर्टी चूंकि सॉरी जो मेन प्रॉपर्टी है वो बड़ा है, 8.5 एकड़ में 2.5 एकड़ हम लिए, 4 एकड़ एक भाई लिया, एक भाई को कुछ लैंड गया, अब ये जो है जो दूसरे भाई थे कालीचरण झा जो डिफेंडेंट 9 है, उनसे खरीदे थे डिफेंडेंट नंबर 1। अगर वो चैलेंज कर देते कि सेटलमेंट नहीं हुआ या सेटलमेंट हुक्मनामा गलत है और स्टेट की बात लेकर के आते, तो जो 4 एकड़ जमीन खरीदे थे वो जमीन भी उनकी नहीं रहती, क्योंकि पूरी की पूरी सेटलमेंट ही कह देते हैं गलत है। नाउ प्रिजम्पशन पर चला गया appellate कोर्ट, यह कह के चूंकि मेरे फादर है तो इनकार नहीं किया जा सकता। पैराग्राफ 21 ऑनवर्ड,
पढ़िए
इसमें प्रिजम्पशन जो है पेज 19 पर, कहिएगा मैडम पूरा पैराग्राफ 21 पढ़ देते हैं। पेज 19 पर पैराग्राफ 24 उसके मिड में कहते हैं फाइंड एंड होल्ड दैट क्रिएशन ऑफ एग्जिबिट 2 and 1/8 कैन नॉट बी रूल्ड आउट फॉर द वेस्टेड पर्पस ऑफ द प्लेंटिफ। इट इज नॉट द केस ऑफ इवन WWS, इट हैज नॉट बीन डिनाइड कि हमको जो है सॉलिटरी दिया गया था। अगर एक ही 2001 संवत में केवल हमको दिया जाता तो मैटर वुड हैव बीन डिफरेंट। वो पूरा का पूरा लैंड 1361 8.5 एकड़ डिफरेंट पर्सन को सेटल किया गया।
पोजीशन भी डिफेंडेंट को दे दिया।
इसमें पोजीशन क्या है, पर ये जो है डिफेंडेंट जो है आज भी हम पोजीशन पर हैं। ऑन कंसीडरिंग दिस, और काइंडली सी पैराग्राफ 25 में वो लिखते हैं लास्ट पैराग्राफ, लास्ट पेज 20।
पढ़िए पैरा 21 मतलब तेजी से पढ़िए।
No doubt सादा हुक्मनामा एग्जिबिट 2 dated 10 माघ संवत 2001 can be used for the collateral purpose only and it is cannot be confer title to the plaintiff. It may not be out of the place to mention here that the court below has observed that hukumnama is supported by exhibit 1 by A, which is the rent receipt granted by X landlord. It appears from the para 10 of the impugned judgment that court below has wrongly observed the exhibit 1 is the rent receipt dated 15/2/63 granted by state of Bihar in favor of the plaintiff, which is the with respect to jamindari jamabandi number 58 area 2।
ये कैसे है? ये वाला ये फाइंडिंग कैसे?
ये फाइंडिंग ये एग्जिबिट 1 जो है माइलॉट के समय है सामने है,
कुछ नहीं पढ़ा।
उसी का मेरे पास भी है। और वो जो है 1963 का 1963 कोना में लिखा हुआ पढ़ा रहा है, स्टेट ऑफ बिहार का है, 1963 पढ़ा रहा है।
एग्जिबिट 1
3/1/86 का खाली साइन किया हुआ है। यहाँ पे मेरे पास खाली 3/1/86 का
डेट ऑफ एग्जिबिट है ना। All these documents were marked without objection.
विदाउट ऑब्जेक्शन मार्क।
पढ़िए आगे।
Granted by the state of Bihar in favor of the plaintiff with jamabandi number such and such. As a matter of fact, there is no case of plaintiff that any vesting return with respect to the suit land was ever filed or submitted after vesting of jamabandi in the state of Bihar. It is also not the case of the plaintiff that any jamabandi was opened in favor of the plaintiff and that also bearing number 58 is demand register or registered to. It may be not out of place to mention here that jamabandi 58 referred to mentioned in exhibit 1 by A is with regard to the khata number to which the suit plot appertains. In this context, it will not be out of place to mention here that plaintiff Satyanarayan Jha himself not come to the doc support of the case. There is no explanation for his non-examination. I will take a pause over here, my lord. Trial court में आया है कि इनकी तबीयत खराब हो गई थी, ये बेडिडन हो गए थे सत्यनारायण झा, वो चल नहीं सकते थे, उनके बेटे जो है लुक आफ्टर कर रहे थे, इसलिए ही हैज डिपोज्ड प्लेंटिफ विटनेस नंबर 1. That explanation is that has taken note in by the learned trial court. Who could have been most competent witness to witness on this point of the settlement or submission of the return of the suit plot in this favor? His son Harendranath Jha stated at the time of evidence recording in 16 to 20, his father was not maintaining good health, and at the time of his examination, and he used to make parody in the case on his behalf. Admittedly, father of the plaintiff was ex-landlord. Therefore, the creation of Exhibit 2 or Exhibit 1 by A granted by the intermediary for the vested purpose cannot be ruled out. It has to be examined in the light of the fact as to whether the vesting return was ever submitted or filed in his favor to the time vesting of jamindari in the state of Bihar. Especially in the context of special provision made for such case in Chapter 2 of Bihar Land Reforms Act 1950, the learned advocate of the appellant has referred to 3B. He उसको skip कर जा रहे हैं provision को. He has further referred the settlement statement 1 also which form of the particular to be furnished under section 3B3 of the act. The column 8 of which form has been especially prescribed the area which is has possession of intermediary together with the plot number and classification of the said land. Similarly, the column number 9 of the form refers the Gair Marehua Mali land together with the plot number. Column number 13 refers the total area. The learned advocate for the appellant rightly submit that while referring to the section 4 of the aforesaid act at all, the right of the intermediary have absolutely vested in the estate free from all encumbrance with effect from the date of vesting of such proprietor or tenure holder serious to have the interest in such estate or tenure other than the interest expressly saved or by or under the provision of Bihar Land Reforms Act. He further submitted that if the suit land was actually settled by the ex-landlord Aklu Panjha in favor of the plaintiff, there was no question of non-submission of vesting return at the time of vesting jamindari. There is also no case of the plaintiff that any return to the effect ever submitted or any jamabandi was opened in his favor. Therefore, Exhibit 1 has no evidentiary value which has also created purposely. At a matter of fact, the submission made on this behalf of the appellant has much weight. Against this, therefore, discussing the documentary evidence filed on behalf of the contesting defendant, so far as their case settlement of the suit land in their favor of the consent is, it may not out of place to mention here that a description given in the plan and the written statement are distinct in respect of the boundary, but identical in area, plot number and khata number. It appears that Parwana Exhibit C dated such and such an area of 2.5 acre apprehended to plot number 1361 under khata number 50 situated in village Chaudhary Bandh bounded and booted by the Parti Kadim in the north, land of Jhupar Jha in south, and by Parti Kadim in east and west of the settlement settled in favor of Chauhari Devi by the state of Bihar. मतलब ये जो डिस्क्रिप्शन है और सूट लैंड का जो बाउंड्री है दोनों डिफरेंट है. 8.5 एकड़ बाउंड्री है माय लॉर्ड. कोई भी अगर इन वर्स्ट केस कोई अदर पार्ट भी हो सकता है, बट बाउंड्री जब दिया गया है मेरा हुकुमनामा में, दिस सेटलमेंट लैंड एंड दिस लैंड सेटल्ड टू गिवन टू मी बाय वे ऑफ हुकुमनामा, that is not the same land. The state of Bihar, which is the order sheet dated such and such of the circuit officer Bagodar in land settlement case number such and such supports the case of the airport settlement in favor of the Chauhani Devi. Exhibit E in respect of the means submitted in connection with the aforesaid case. Exhibit F is the proclamation made by the settlement of the suit land. There further, the said settlement finds support of the Exhibit A by 13, which is the rent receipt granted by the state of Bihar for the years 1975-76. Similarly, Exhibit A is the rent receipt for the year 1976-77. Exhibit A is the rent receipt dated 26/2/78. Exhibit A by 11 is rent receipt dated 6/2/79. Exhibit A by 1 is rent receipt dated 26/2/81. A by 6 is rent receipt dated 83. A by 7 is rent receipt dated 19/11/83. Exhibit A by 8 is rent receipt dated 3/31/85. Exhibit A by 1 is rent receipt 22/2/86. Exhibit A by 2 is rent receipt dated 7/3/87. All granted by the State of Bihar in favor of defendant number 2. It may not out to place to mention that other rent receipt of the Exhibit A series with respect to the land measuring 4 acres said to have been purchased by defendant number 1 Hari Narayan Jha since that from the Hajam from Kali Charan Jha appertains to the same plot under the same khata.
उनका भी बोल दिया, उनका भी सेटलमेंट बस विदाउट नोटिस एंड विदाउट फॉलोइंग द प्रोसीजर। डिफेंडेंट को भी तो दिया नहीं कुछ,
उनको कहा दिया कि जो सेटलमेंट है वो सही है, और वो सेटलमेंट गलत सिर्फ इसलिए नहीं हो सकता है कि co-heir जो है हमको एक पार्ट ऑफ द लैंड बेच दी है। दैट इज द लास्ट फाइंडिंग।
कालीचरण झा जो है सो उसको
तो कालीचरण झा को भी सेटलमेंट हुआ है, और इतना ही नहीं, इनके लिए क्षतिपूर्ति केस भी हुआ था, दो इट कुड नॉट बी ब्रॉट ऑन रिकॉर्ड। पार्ट 23 it has been pleaded by the plaintiff that Anchal Adhikari Bagodar has no authority to make any settlement within the plot number 1361 under khata number 58 village Chaudhary Band, in which the plaintiff and other co-heir had already acquired royalty rights, as the said plot as well as the along in past possession of the ex-intermediaries and their descendants including the plaintiff. Besides that, the said settlement was challenged on the ground that the defendant number 2 was not a landless lady, and the said settlement was made beyond the notice of the plaintiff, who has not been examined as stated above. But at a matter of fact, the said settlement was not challenged by the plaintiff before the proper forum whatsoever. So, after averment of the plaintiff made in the plaint to this effect, is concerned that the said settlement was made behind his back, and notice it may not out of place to mention here that there is no evidence on record by way of suggestion even that the said settlement was made behind the back of
and without notice
of the plaintiff, whereas the document with respect to the said settlement as well as the proclamation made in that connection have been filed on behalf of defendant number 2. So far, coming into the possession of the land by defendant number 2 after the settlement is concerned, the rent received referred award raised presumption in favor of her possession. DW7 Johani Devi has stated in her evidence that she came in the possession of the suit land, and after settlement she is cultivating possession thereof, which finds supports from the evidence of DW8, DW11, DW12 as well. In fact, the circumstances I find and hold the creation of Exhibit 2 and Exhibit 1 by A cannot be ruled out for the vested purpose of the plaintiffs after such settlement in favor of defendant number 2, as submitted by the learned advocate of the appellate. I also find and hold that so far the evidence on the point of possession is concerned, the evidence adduced on behalf of the defendant is much superior to that of the plaintiff. In fact, the circumstances of the above contrary to the finding of the court below on the point of settlement in favor of the plaintiff by the ex-landlord, who was none less but the father of the plaintiff himself. I find and hold the story of settlement as set up by the plaintiff cannot be accepted, and I also find and hold that the right of the intermediaries with respect to the suit land has absolutely vested in the state of Bihar after vesting of jamindari under provision of Bihar Land Reforms Act, And as such, question of becoming Rayyat after vesting of jamindari does not arise
So
consequently.
these two documents, your hukumnama and your rent receipt given by the ex-zamindar,
My lord.
have not been declared forged and fabricated as such.
Pardon?
Have not been declared forged
Forged and fabricated.
by both
It-
appellants.
by the board. It has been only doubted by the appellate.
But no clear finding.
There is no clear finding. And as my lord has said, it is covered by the Ugni Devi, though in fact I have only brought one judgment. That is the Ugni versus. Even I have gone through, though it is considering this, my lord has passed one judgment in different case, that is the Balkishun Ram case. In that case, there was a finding and there is a doubt upon the.
ऐसे नंबर
वो जो था ऐसे नंबर माय लॉर्ड वो है 380/2017, उसमें उगनी को हम कॉपी फॉरवर्ड कर रहे हैं। उसमें माय लॉर्ड का सेक्शन पैराग्राफ 70 के बाद होल्ड किया गया कि बोथ द कोर्ट, उस केस में बोथ द कोर्ट जो था वो डाउट किया था इसमें सब्सटेंशियल क्वेश्चन नंबर 2 पैरा 70 ऑनवर्ड, and that's why it is distinguishable. पैराग्राफ से सो फार सेकंड सबसेक्शन सब्सटेंशियल क्वेश्चन यही था कि वो उगनी वर्सेस जिस केस से वो कवर्ड है कि नहीं। इसमें फाइंडिंग आया माय लॉर्ड का कि
कोई फाइंडिंग ऑफ फैक्ट रिकॉर्ड कर दिया है फर्स्ट अपीलेट कोर्ट कि ये जो आपका हुक्मनामा है और ये जो रेंट रिसीट है दे आर नॉट रिलायबल डॉक्यूमेंट्स, देन दैट इज नॉट द सब्सटेंशियल क्वेश्चन।
दैट इज नॉट सब्सटेंशियल क्वेश्चन।
So therefore, on the face of the finding which is facing you right now, how can you rely upon it? In Ugni
Because
Devi, it
Ugni
was an
Devi is-
undisputed fact that there was a hukumnama followed by repeated zamindari rent receipts.
That is same my case. There is no finding of the appellate court on the point कि it is
So
forced.
far as Exhibit 1 is concerned,
one by
you show me that the learned appellate court has said that it is not a rent receipt issued by the state government. That finding has also become final because first appellate court is the final court of fact and law.
उन्होंने कहा दिया है कि 58 के लिए नहीं है और Nugget predicts it, though the trial court has stated ये 58 के लिए जब भी होगा, that has also been marked exhibit without objection.
Without objection
क्योंकि
does
अगर
not
वो
mean that
58
the
के लिए नहीं
proof
होता,
document has
अगर उस खाता 58 के लिए नहीं होता, they would have objected even though that could not be exhibited because that does not belong to the suit land. मेरा सूट लेन तो 1361 खाता 58 का ही था ना, चूंकि अभी इलिजिबल मेरे कॉपी में भी हो गया और माय लॉर्ड का ही कॉपी में हो गया।
नहीं, अभी नहीं हो गया है। appellate court के समय भी चीजें इलिजिबल ही थी। It was not clear, वहाँ पे नहीं, एक फाइंडिंग रिकॉर्ड कर दिया appellate court ने, that finding is not under challenge. Now you tell us, how will I interfere with that finding in the appellate, in second appellate jurisdiction? That finding stands as it is.
The only substantial question was framed in this case whether that is whether a sada hukumnama in respect of the original tenure holder coupled with the issuance of rent receipt and delivery of possession issue in favor of the plaintiff will confer valid right, title and interest. Now hukumnama that has not been challenged.
So exhibit 1 becomes meaningless.
क्योंकि
Exhibit what remains is
Exhibit 1
2
by A.
and Exhibit 1 by A. Exhibit 1 by A is the zamindari rent receipt.
my lord
And Exhibit 2 is the hukumnama,
hukumnama,
right? Identity of the property has been duly established.
my lord, that has
So
also been
once-
stated in hukumnama.
Once the hukumnama is proved, which is followed by a zamindari rent receipt, then under such circumstances,
Ugni Devi will help me, my lord.
Ugni Devi का
आपको my lord the first case AFAD. This is 5 judgment of the Honorable Patna High Court. It's a paragraph 16. एक बार पेज नंबर 3 देखा जाए. By the virtue of Sada Hukumnama, Rayati title cannot be conferred by the Sada Hukumnama coupled with rent certificate, even though oral settlement coupled with the rent certificate could confer good title. ये जो था appellate court का finding था. Now considering all the other judgment, 2 judges, 3 judges bench which were prevailing at that point of time, paragraph 60, last 3 line. Sorry, my lord, last S line. The unregistered, my lord got it. The unregistered Hukumnama, though inadmissible, could be looked into to show the nature and character of the possession. Over oral evidence of the terms of the lease will not be admissible, but independent of Hukumnama, the rent received themselves indicate that the rate of the rent and area and nature of the right of the lease, hence dependent of the Hukumnama, the terms of Rayati settlement was inferable from the other piece of the evidence, which is rightly relied by the lower appellate court, and there is no error that would justify to interfere the second appeal.
Para 16 पूरा पढ़िए.
My lord. For this reason would hold that the full bench decision of 1964, on which Mr. Prem Lal relied, will not apply here, in which there was a clear finding of the lower court that plaintiff came over the actual possession of the land, continued in the possession and paid rent to the landlord obtained by the rent receipts of the disputed rent. On this finding, the Rayati interest was established. The possession and finding of the plaintiff as found would more than 12 years, and hence even in the absence of the finding that plaintiff was settled Rayat of the village, occupant right could accrue to them. To such importance would not attach to the somewhat incorrect observation in paragraph 12 of the judgment of the lower appellate court quoted above. In the above, it is clear discussion that oral evidence of the possession in paragraph 12 is the finding in favor of the plaintiff. It is also held that disagreeing with the trial court, the rent receipt produced by the plaintiff were in respect of the disputed.
The possession is also not in your favor.
Possession is my favor.
No. The finding of the learned appellate court.
Learned appellate court said कि not in possession. That's why I am saying कि अगर वो जमीन, क्योंकि जब प्लीडर कमिश्नर का रिपोर्ट देखा जाए, प्लीडर कमिश्नर के रिपोर्ट में ही पोजीशन मेरे फेवर में लिखा गया है. 7 क्यारी लिखा गया है, 7 क्यारी के बाद पोजीशन बताया गया, पोजीशन मेरे फेवर में है. That the प्लीडर कमिश्नर रिपोर्ट says. Now वो एक जमीन लेकर के आते हैं bounded by the others boundaries, और उसके लिए कहते हैं वो मेरे पोजीशन में नहीं है. 8.5 एकड़ में कोई दूसरा जमीन हो सकता है, पर वो जमीन नहीं है जो हमको by the way of the सादा हुक्मनामा सेटल किया गया है. That's why pleader commissioner report regarding the possession has taken note by the Senate trial.
Second appellate.
ठीक बंद करो 61 से